Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
All right, I've mixed things around. I don't know where my volume is anymore. Let's see. I think we are right here. That's it. Found it. Good morning. Good morning. Top of the Monday morning to you. Welcome to the Court of Public Opinion. I am Recovery Addict. And I think I can even make myself appear on the screen. There. It's like magic. I'm here. Good morning. It is a fantastic week ahead of us. As long as your name isn't Murdaugh. Murdoch is going to have a bad week, I think. And we'll be there to watch, just to see what happens. Tons of people in chat. Let me just take a quick look here and see who was first. Yep, 6 Volt Bus. 6 Volt Bus, congratulations on being first in chat. You've done this before. You are a repeat winner, excuse me. Always mix that up. But thank you for being first in chat, breaking the ice, letting everybody in. As a reward, you win the internet. You are first in chat, and you win the internet with that first chat. So congratulations. I know you're capable. You've done it before, so just do it again, and we will not complain. Lots of other people here as well. Looks like Mr. Murdaugh possibly just arrived in court. So we're just waiting for him to pull in. Let's see, what's happening right now? I'll just getting a nice white balance. A little overexposed there. Too much sunshine this morning. It's a little bit early still. How was everybody's weekend? If I'm yelling a little bit, it's because I can't hear myself. And it's not a problem with my equipment at all. Some of you might have noticed I posted that I was chaperoning a youth dance on Saturday in New Bern, North Carolina, a very historic town. The home of Pepsi. Some of you noted that as well. It's where Pepsi was invented or discovered, depending on how you look at it. But yeah, I went there, and holy cow, I do not remember dances being that loud when I was a youngster. I do not, and my ears are still ringing. But anyway, that was neither here nor there. But we're going to go ahead and begin today with some fun stuff. Let's do a quick roll call, see who we have here in chat, because it looks like we've got about 135 of you, 101 of which have not clicked the like button, I might add. So I'm going to call you all out as I read your name. Shells, good morning. Sunshine Sunflowers, Victoria S. Let's see, we are all doing great. Adam Nusky is here. Golden Mom, good morning to you, Golden Mom. I like the not first hashtag from Sunshine and Sunflowers. Let's see, Laura's here. Ritz, Bite Me, good morning. Hope you had a great weekend. I did. I had a wonderful weekend. Golden Girl, Elizabeth Norton, good morning to you. Eric's here. Nurgle, good to see Eric. Tracy, DMB Secondus, Kaylee. Picky, good morning, Picky. Sam Bellissimo, good morning, all and recovery. Good morning to you, Sam. Good to have you. WV, Denise, CJ, Christy, Linda, Samantha, Terry, Maui Girl, back from Hawaii, 3:55 a.m. Wow, super early. How do you do it, Maui Girl? I just don't know. I don't think I could do 3:55 in the morning on a Monday anywhere, even if it was in Hawaii. Maybe if I was metal detecting the beach in Hawaii, I would do a 4 o'clock in the morning. That might be fun. Myra's here. Good morning. Go for a run. Be back in a minute. Okay, Miss Chris, Kathy, good to have you as well. Keisha B, I see you there, Lindsay Hendricks. Good morning, my loves, from beautiful sunny Texas. It's finally warming up down there, right? Has the frost moved on? Angie KH in South Carolina is here. Ritz meant to say lovely people earlier. Guess I knew more coffee and donuts. Let's see. I am Omni 008 is here. Kelly Sibald. Bernard G. T.A. Good morning, T.A. Not a Drama Llama's in the house. See, everyone's in here. Got you guys already. I'm trying really hard not to call people out twice. Samantha Baggett. Roxy Moser. Kelly Javisto. My dog Murray. KX Star, good morning as well. Natalie Lintz. Myra, gotcha. Mississippi Raptors and Reptiles. Samantha Baggett and Samantha Terry side by side, sitting side by side today, the two Samanthas they are. Let's see, Linda, Mac, Victoria S, Ashley R, says Camel. Sorry, I think I'm not sure if they're turned on right now. Let me check. I don't think they are. I think we turned them off the other day.
I'm not a camel.
There's your camel for you, Ashley. Christy Mariolin, here we go. Ignore me. I see you already. Sorry, I missed your name instruction, but I called you out. Share Bear, Lindsay Lynn, Participation Trophy Wife. Love this name. Participation Trophy Wife is here. Lindsay Hendricks, Barnett Law Student, good to have you in the house. Love to get your insight on some of what's going on today. Specifically, maybe for those of you that have a legal mindset and are critical somewhat of evidence in these cases. Where do you guys stand on the tool markings, on the firearm tool markings? I know a couple people are just, it seems like pseudoscience, and it shouldn't be allowed. Others think that it's right up there with fingerprinting. Anyway, Jennifer Cardillo, Jiggly Jules, Pete Stone, Jill Hipple, good morning. Tish, good morning, Tish. It's Monday. I feel fantastic. Well, sort of. 6 a.m. is early. I'm sleepy. We'll let you sleep in the front row. Just go pull up a chair and bring a cushion and just lay down. Until everyone arrives, you can sort of use some extra space. It's over there. Laura says it's over there. I forgot what you were telling me about. Jimmy King is here. Good morning, Jimmy. Let's see, Fractured 23, Share Bear, just Tom, and it just skipped everybody. Man, I have to scroll back up to see where I was. Lady Writer, Sherry Zibar, Maribeth Robinson, Carly 196. Listening to the podcast about AM, it's quite some story. Oh my goodness, is it ever? It's crazy. If you guys have been following along in Discord, the documents that have been posted there, it tells such an incredible story. Looking at all the timelines that have been put together, looking at the backstory and the history of Murdoch involvement, namely specifically his son Paul with the police, and how many times it looks like things just sort of got smoothed over, and then looking back all the way up to the death of the guy that was found on the road, and maybe the connection they had there, and why it was ruled a hit and run when apparently he had a gunshot wound to the head. Crazy things back there. It's starting to look very suspicious. I don't think at this point I would want to be an associate of the Murdaughs if he's found not guilty, because lots of scary things have happened to a lot of people they know. Lindsay Hendricks, Samantha Terry, Ashley R, Roxy Moser, Hannah, Vixen, Amber, we still need to talk. You worked probably all weekend, and I've been following some of your posts online. We might need to have you dial in and talk to us and walk us through some of what you've seen. There's so much out there, and drawing the connections and putting everything together in the order it happened in. It's crazy. Richard's here on Globe. Good to have you. Let's see, CJ, congrats to 6 volts, or condolences, depending on how you view it. Maggie Sale, Scotland, watching with great interest while thinking how we have responsible gun control. Good to have you, Maggie. Michelle Johnson, Sharon McDonald, Wallflower, Last Poet, Ignore Me is here again. Mississippi Raptors and Reptiles, did I get you already? We say howdy here, always on go. DMB Secondus. Twisted Branches, good morning. Patricia as well. Toxic Orchid, good morning, Toxic. Let's see, Picky from sunny Louisiana. We're happy to see this on. Do you guys see how many earthquakes were over in Turkey in the last 12 hours or so? I mean, big ones, 7.5, 7.8 earthquakes. I have not seen the damage yet, but that does not look good. Portland Trailblazers TV, you're here. Vicky C67 is here as well. Cakes Boo. Tag, good morning, peeps. Good to have you, Tag. Veronica Reeves as well. Linda Laferriere. Linda, one day I'll get your name right. I got the first name right. I'm pretty sure it's Linda. Queen Olive is here. Good morning to you. Yims, are they housing him in jail or a hotel room? It is jail. We call it a hotel, but it's definitely jail. Horse Sheet and Bananas is here. Good morning to you, Horse Sheet. Mountain Mama. Linda Hill. I see you, Linda. Gotcha. Christy P. Jessica Lagalbo. Good to have you. Buenos dias from Tejas. Is it Tejas? I assume. Rhonda is here. Ann Shatchner. Kelly Harper. It's Marissa. Cindy. I see you, Cindy. Cindy Santa Fields. Georgia Carver. Let's see. Did I miss anyone? Raise your hands here if I missed anyone. We're coming down to the end. Linda. O-Town Chills here. Good morning from Ogden, O-Town. I think Rihanna is here. Ginger Meadows. Canes fan. Let's see, it looks like pretty much most of you have gone ahead and clicked the like button as I called out your name, so it's working. Blaise Dewar, thank you very much. Shauna Cothran is here as well. And Andy Mia is good. Is here for praying for Turkey. Yeah. Sorry, I thought you said from Turkey. My eyes are a little blurry this morning as well. Yucky's in the house. Jay Hughes. Babs09X is here. 70s here in Texas, says Holly Henderson. That's not bad. I won't complain about 70s. Grit Grinder, good to have you. True Celtic Mutt is here from Virginia, I assume still. Let me know if you move. JK is here. Tag, Yucky. I think we got you guys. I think we're all caught up. Are we all caught up? Barb Murray, I see you there. Yucky, Nancy, Eileen. Got Last Poet, Holly Henderson. I am Ami008, Samantha Terry. I'm just looking for ones that have hands now. Jen Hoff, Jay Breezy, Terry Korniak. I messed these up and I feel awful. I wouldn't want you to say my name wrong, but I don't know how to say it any better. Barb Murray. Will Darrell Brooks represent himself in the upcoming trials? I think he's trying to. And if the judge is wise, he might say no. Broadway Garden is here. Norma. I see you, Norma. Good morning. JB. Morning, JB, says Tag. Yes, big shout out to JB up in Canada, the frozen tundra of the north. He's joining us here this morning. See, Misty Farley, Samantha Terry. I think we got everybody. Max says, I want to pick the hat. The hat I think you're talking about is the hat I made on Saturday. If you guys missed it, we had a quick stream on Saturday where I was wearing a tinfoil hat, obviously for the situation which required it with the balloon that the U.S. ended up shooting down after it finished its spy mission, because we didn't want it to interrupt anything, because that would be rude. How would China feel about that if we stopped it before it was done taking pictures and transmitting back to the mother country? Anyway, so we let it finish its job, and then we shot it down over the Atlantic Ocean, and it fell in the water out there by Myrtle Beach, South Carolina. The balloon killed the Murdaughs. It's funny. Let's see. Let me get the live stream going from South Carolina. It's looking, it's searching. I re-rigged some of my stuff around my desk. It looks the same, but I changed the order of the plugs. Can the judge deny Gerald Brooks from representing himself? Barb, yes, but really he has to have reason, because it's sort of one of those things that you get to do unless you're not capable, like mentally, of representing yourself. So as long as he is like halfway coherent and very adamant about it, he probably will get to represent himself. Let's see. There's an earthquake thread in the Facebook group. Weather Watch is late. Is Weather Watch still on his vacation? There goes a fire truck. And another police car. Oh, they're zipping by. Everyone blow major kisses to Callie Vixen for all her hard work wheeling and dealing with the dock ferry. Oh my goodness. If you haven't followed the documents she's dropped in Discord, you want to do that. And there's so much. I don't know where to start today, this morning. I saw someone on Twitter poking fun of the kid who was believed to have been in the weather balloon a few years ago. Oh, the balloon boy thing. China got the idea from Balloon Boy. Grit Grinder says, my mom is a snowbird in Myrtle Beach and watches the balloon stuff from her balcony. It's like a front row seat. It's better than the fireworks show. You know, a jet comes in, pops the balloon. That's pretty cool. Isn't it a constitutional right to represent himself? Yes, but if you're not like mentally there, the judge will say you're not able to do that. Like if you can't understand and communicate and do the things that are necessary to represent yourself in court, the judge will not let you do it. He did such a good job the first time. Yes, Barb, he did fantastic. He should charge himself double the price as his first representation. We're almost prepped for the alien balloon invasion. My deep freezer gets delivered on Wednesday for reals. You're going to fill it full of food. Looks like meat. It's going to be a meat freezer. Trying to see who's coming to court. Who's this? Is this is that Nancy? No. There's Buster. Good morning, Buster, with girlfriend. Buster, the surviving child. Looks like he has a guard, a sheriff's guard, with him. Probably because of the threats and the risk to him and everything. Mission accomplished. You're all safe. Good job, Sheriff. Let's see. KQD is here. Good to have you, KQD. There will be documents found in balloon debris. If there are, Amber's going to find them. Maybe the only way we see the Boone trial is if she was her own lawyer. You think what happened in the Boone trial that would? Other than the delays, I think it'll still be televised. It's in Florida, after all. Let's see. Weather Watch is on the lam after last week's cold front. I heard the jet used our cheap missile to take out the balloon, a mere $44,000. Oh, man, don't miss at that price, you know. Recovery Addict. Word around town is a civil suit is coming to the mom just for future revenue. Civil suit to whose mom? We've got so many things going on. This morning, Aiden Fucci, I don't know how to say his last name. The 14-year-old stabbed his 13-year-old friend to death 114 times. That trial begins this morning with jury selection. We also have Courtney from the OnlyFans trial is having a hearing today. I think it's just a status hearing, so we'll probably catch word of that later in the day or tomorrow as far as how that goes. It would be nice to hear a firm date on her trial as well, because so far everything's just been pushed off. Probably will be again, quite honestly. Is he the sheriff? Couldn't tell. I don't think he's the sheriff. I think he's a sheriff's deputy, but all the sheriff deputies basically carry the badge of the sheriff type thing. They have his authority. I hit the like button when you finally call my name and was wait for it. Wait for it. I see you. Thank you very much. I appreciate you being here. See, Daryl Brooks' mom's going to get the suit because she lied about the car. Is that it? Fucci. Okay, I'll remember Fucci. He's been eating like a rat in jail. Do you guys buy any of this if you follow this?
To another week of great court watching and interpretation. Scott jempol ke atas dengan warna kulit terang sedang, jempol ke atas dengan warna kulit terang sedang.
Okay, so when I told us to use random voices, I didn't know I was going to use random languages. Bernard G came in with the super chat. He says, "Here's to another week of great court watching and interpretation, Scott," and 2 thumbs up. Thank you very much. I appreciate that, Bernard. Generous super chat to start the week off. It's going to be exciting. It's going to be really cool. Let me get the court feed coming here from before I forget. Let's see, who do we want? WLTX, where they were good last week. They weren't too bad. Okay. That's not it. Let's turn off audio on 2 for now. There we go. Okay. Audio's on. All right. Thank you very much, Bernard. Still no feed from the courtroom yet. You probably know the balloon was shot down by a F-22 and a Sidewinder. Yes, Richard, I love the F-22. The F-22 sound is fantastic. Why is my audio so low on this? I'm going to turn that up. Sorry about that. It should be a little better now.
I wish I could gift membership, but using the phone I don't have that option. がっかりした顔.
Okay, I need to change my settings. I didn't realize how random was. Roxy comes in with, "I wish I could gift memberships, but I'm using the phone. I don't have that option." Thank you for the $10 super chat, Roxy. You're amazing. Just being here is enough, but your generous donation is super appreciated. Thank you very much. Yeah, phones have a hard time giving gifting memberships. We are having a 404B hearing again this morning. Yes, and for at least a couple hours. And then we hope that the judge is going to rule on that. We might find out today what he's going to allow. It could be after lunch. I would be surprised if he rules immediately after the 404B hearing ends, because he probably wants to mull it over a little bit. And even if he's already made his decision, it would look better if he had a short break and then came out and ruled on it. So probably after lunch. It's possible these were fired from the same weapon. They also possibly weren't. The definition of inconclusive, according to the state's ballistics expert, Barnett Law, you are not wrong on that. I think that testimony was not helpful to the state to say, I can't say if these were fired by the same gun, but they were cycled through the action. I mean, as far as like reasonable doubt goes, how many of you think that the killer took the bullets and cycled them through one gun, just loaded it and cycled it through and ejected it without fire and everything, and then loaded it into the killer's weapon and loaded it? It's like, just because of, there's some variation on the firing pin, and it could have shot it, but all the other marks are there. I think he could have probably testified a little bit differently, and it would have been a little bit better, but I don't know. Some people are saying nobody can point that out anyway. Ashley, member for 1 month, says, I don't know what this is. This is your 1 month, your time to highlight a message. That's it. You just get a free little bright message with your month anniversary. I guess that's the term. Congratulations. Thank you very much for your month anniversary. And look at that. Your color turned. You're now a little light aqua sort of color on your courthouse. Looks good on you. Like Gucci, but with an F. Fucci, like Gucci. Always on the go. I'll remember that now. Like Gucci, but with an F. Fucci. Barb says, I'm not sure what's in the water here, but I just finished the retrial of Mark Jensen. I think we're close.
Dr. Watson dug this super chat up in the yard. Bone.
Dr. Watson dug the super chat up in the yard with a bone. That was a little easier to hear, Tag. Thank you very much for that, by the way. Hope Dr. Watson is doing great. I know I've seen a couple pictures of him. Nice fur baby. Let's see, there's evidently another balloon or two in Central and South America. I wonder what they're going to do with their balloons now that we've shown that we can pop ours with a $44,000 missile fired from a $3.5 billion jet or whatever it is. Let's see. That was fun. 1 month anniversary. Well, that was fun. As well, Suzanne, thanks so much for everyone here, but the mods, thanks so much for everyone here. The mods and RA, love it. Suzanne, thank you very much for that membership month anniversary message as well. It's going to be a fun one today as we're getting started. I just got the feed from the courtroom here just a moment ago. Looks like it's working. So we'll keep an eye on that. Our audio is turned on. So hopefully we'll have something coming from the court soon, as the judge is due here in about 5 minutes. 5 minutes to start. Let's see. ASN promised I hit the like button. I'm going to leave this. I have to start motivating you to like more in the future. Wait for it. I see you. I see you for sure. I apologize. I just missed so many. Goofy. Not sure what that is. Oh, Roxy Moser figured out how to gift memberships because she just gifted 5. Let me see who won here. We have WV, Linda Hill, Beth. I'd rather be day working. Congratulations, I'd rather be day working, and Chandra, all gifted membership by Roxy Moser. Congratulations to all of you. Some of you second time around. It's your second month, so you might have a month anniversary message waiting for you here soon. Let's see. Tish says, I was thinking of Gucci, but with an F. My mind went to Goofy or Goofy. Yeah. I was thinking something else, and I didn't want to say it. I probably will accidentally, and then I'll be super embarrassed. But I thought it was more of a K sound. And then it's probably going to slip out. I'm definitely not pro Murdaugh. Going into the trial, I thought it was the shooter, says Jill. The trial's changed my opinion. Make no mistake, he's involved in some way. So Jill, you're saying you think he might be involved and knew what was going on, but not the shooter. So who would you put your money on the shooter? Would you say that the was it cousin Eddie? Was he be involved in any way? Because other people showed up to the crime scene before the police, right? Isn't that true? Or were they? Was that not the case? I might have been making that up. I'm trying to think here if that happened. Let's see. Let's go live here. Okay. What you got? Oh, I'm good. Good thing. Sorry. We're gonna do a little bit of ASMR. Quick ASMR moment. I need to fill up the mug. I'm using the red True Crime Addict mug today. Got some water. Thanks to Deer Park for nothing, because they still aren't sponsoring the show. There we go. I have some other news in the pickle world to tell you. We're not talking Jensen. We're talking actual pickles. And that is that Walmart is not the only one selling spicy maple bourbon pickles. Food Lion also sells spicy maple bourbon pickles that are exactly the same. The same lid, the same jar, the same markings on the jar, the same marking on the lid, the same printing machine that shows what factory and timestamp they were made at. Everything is exactly the same. They taste the same. I did a blind taste test, and they are identical. But they cost, what is it? 15 cents more. A Food Lion. So now I know that there's at least 2. Yep, Food Lion. I'm telling you, Food Lion has them. The jar is identical. You could swap the labels and no one would know. Yeah, quick bathroom break for all of you. Sorry about the ASMR. I will mind the laptop, Katrina. Thank you. Professor Phil Bell says, "Is that the plaque, the state shield of South Carolina?" Yes, I believe it is. I think that's the seal. It might be. It's got like crossed cannons over a palm tree or something, coconut tree. I don't know what it is. Old school anti-aircraft flak would have been cool to take a balloon down with. That would have been awesome to see. I think they should have had a contest, just especially up there in Montana where the risk of hitting someone was much lower. just because of how much open space you have. At least then we wouldn't have to be fishing at the bottom of the ocean trying to find pieces of metal. Cachette, good to have you here. Welcome. Roxy says I changed my name so people don't get me and Roxanne confused. Let's see. I think 6 volt bus. I think there is some gain to it. If you go back through Discord and start looking through some of the stuff that Amber's been posting over the weekend on this, I think you'll see that some of the assets that belong to Maggie, that were originally scheduled to go to her sister, got changed into Alex Murdaugh's name. Things like the farm. And her sister wasn't aware that anything had ever changed. So suddenly that her death suddenly becomes a financial boon to him, especially when you look at the allegations that she had gone and seen a divorce lawyer, that she was looking at separating, and he would possibly lose out on a lot of that. So there's starting to be, I'm not sure what's going to be presented today, but there's starting to be a clearer picture as to a motive for Alex Murdaugh. What's your thoughts about the mom who killed 3 children and jumped out the window? Oh, I haven't looked at that one, Barb. That would be awful. Man. My Walmart doesn't carry them, so now I'm off to Food Lion. I've been through Food Lion like 4 times looking at the pickle section. I'd never seen these. I don't know when they showed up, but they're there now. There was a guy Alex Murdaugh kept telling Buster to get money from on the jailhouse calls. What's his name? I think he helped Alex Murdaugh. Yeah, there's a couple people that got checks from the Murdaughs over the last few years, and quite a bit of money. No Food Lion in Davis County. It is more of an Eastern thing, I think. Trying to think what the equivalent would be. It's not like a Smith's Kroger's thing. It's sort of its standalone chain. Yes, it's a seal. I had it on my badge for 17 years. It's a pretty seal. I like how detailed it is. What's on the right? It's like a Lady Liberty holding a plant of some kind. Good morning, Illinois Mama. We're about ready to get started. Things are moving around in court right now, so hopefully it's something soon. Would you consider streaming on Rumble too? Says Kit. I need to learn more about it. Here's the thing. If Rumble requires you to pay, I would sort of probably not want to do that. I'd like to have it open so that anyone can watch without paying. Anyone can participate. Everyone can ask a question. If there's a free watch version on Rumble, I might do that. I like having people be able to participate without having to pay. That's just something I think is important. It's important to the discussion. Mrs. Wollever, Kids Can Draw. I made it. Hello to all. It's early here in Southern California. You are early. Hopefully we'll be able to have a great day with you here today. Let's see, I haven't read the info you posted. You've got to look through, pull up Discord and take a look at it. It's good, great stuff. Documents, excerpts, goes into was it Stephen Smith? The death of Stephen Smith years ago, and how maybe one of the Murdaughs was involved in that. I spent my morning listening to a dude reading the Bible verses from his car in the Casey's parking lot to a YouTube audience. Well, there you go. That's one way to start the day. I mean, there are worse ways, Cachette. Almost time for the grumpy bailiff to do his thing. Yeah, I've got the sound on, so if he starts yelling and they connect it, oh, thank you for that seal. I just Danielle just sent me the Sunshine Sunflowers sent me the seal for the state, and it is beautiful, even on my Apple Watch. Lots of colors. It makes a little more sense there. Lots of greenery, too, on there. Lots of plants. You guys get balloons, and we get a Navy ship in Australia. I think the Navy ship would have shot down the balloon. So I did read your teaser text this weekend. I did. I tried to call you back. Amber, but I think you were asleep. If you check your phone record, you've got a missed call from the burner phone. Let's see. YouTube is confused. Yes, it is. There's Roxy's new member month-anniversary message, I think. Thank you very much, Roxy. Appreciate you being here. Thank you so much for your support. You're amazing. Like the stream, y'all. That's an order from Cachette. So there's a way to stream on Rumble without charging people money. I might do that. I do think that it's important for me at some point to branch out to another format other than YouTube, just because I've got too many friends on platforms that have had somebody sort of hijack, either steal their password, break in, do something. Somebody complains erroneously and an account gets shut down for a long time and it's really hard to recover from. I would hate to have that happen. I'd like to have multiple levels of how to broadcast. We're getting there. I think once my fiber internet arrives in about 2 months, I'll have the bandwidth to be able to push out dual streams. And we'll do that. We probably might even do 3, one to Facebook, one to YouTube, and then we'll go somewhere else as well. The nurse and delivery mom of 3 that killed kids due to postpartum is such a sad case. Oh my goodness. Hannah, that is really devastating. Started watching Low Country, have a whole new level of disgust for this family. Yeah, it sort of makes you understand why nobody's showing up to court locally, that the courtroom's empty pretty much. It's just people from out of town. We can't get those pickles in Canada. Well, yucky, you're going to have to get the old passport ready and make a trip across the border, because I'm sure we could get some for you on the other side of the border. Is that something you'd think you could get past the guards on the way back in? Maybe if you got an extra jar for them or something. I'm not saying you should bribe. I wouldn't suggest, even in my fondest dreams, suggest you should bribe a border guard for anything. Let's see. Okay, we're gonna probably get Amber on the phone at some point. If we have a good break today, maybe we'll do that during the day. I'll check and see if she's available. I heard on the podcast the law is checking out Handsome's grave looking for guns. I would be surprised, Karen, if I were there. I would be super surprised. That's not the sort of thing you can sort of bring back.
Marjolagen de Jagermar. Yo, line. Just sent a super sticker with 6.
Mario Line, thank you so much for the super sticker with a big bravo on it. I appreciate that, all the way from the Netherlands. Thank you, and have a wonderful day today. I'm glad you could be here. Ivan's here. Good morning, Ivan. You're a little late. It's okay. Court's just getting ready to get started, so any moment now. We'll get going. Rumble is free. I'll check it out. I'll check out Rumble. I know that YouTube demonetizes videos. Like I played the new, if you guys watched, if you were here early enough, you saw the intro. I played my new intro video, which actually has the dog bite section in it. And the time it says, why is the dog biting this one? You actually see the dog that was biting it that they were talking about. So I'm pretty sure that YouTube's going to probably zing me on that one. They don't like that one. Even though it's a little blurry, they tend to demonetize my videos over stupid things like that. I may be able to help smuggling pickles. Got to be easier than my past life activities, says Ivan. Yeah, I mean, if they find pickles, what are they going to do? Is it like, hey, you're smuggling these fantastic pickles into the country. Where do I get some? Do I like pickled onions? I have not had them before. I've had pickled peppers, but not pickled onions. I really was not very adventurous with foods for most of my life. True Celtic says Rumble is free as soon as you reach 100 subs. I will go in live from there, so the Gavel Hounds will be on YouTube and Rumble. Okay, On a Global tested positive for COVID a day after shooting down the balloon. Coincidence? I think not. Richard, oh man, that's no fun.
Rossi from Tucson just sent a super sticker with 5.
Thank you very much. Nope, court's in session. We have to sort of be quiet. Hang on. They just waited till the bailiff stopped yelling, and that's when they turned the mic on. Thank you for the super sticker. Starting the 404B. That means the jury's not going to be here. We're going to go straight to, do they have any business this morning? And then call your next witness.
Good morning. You ready to proceed? May proceed.
Okay.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
Mark Tinsley, another gray suit. Okay, so this is still 404B. This is basically day 3 of 404B testimony. The judge has not ruled on this yet. At some point after this, he's going to rule, possibly today.
So help you God.
I do.
Take a seat in the witness stand. State
Nancy, your
name
chats
again
are
for the
showing up.
records.
I see
Spell
them.
your last name.
Morning, Your Honor. My name is Mark Tinsley.
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would were you testifying before the jury. Do you understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
Morning, Matthew. Good to have you here this morning. Thanks for
And,
the witness information that we pinned on the chat.
How long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
Do you have a statewide practice, or is it primarily?
To the extent I want it statewide, I mean, I handle cases statewide if I'm inclined to handle those.
Okay.
It's a weird answer.
Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
And the 1st? Okay. Do you know the defendant, Alex Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the 2 counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with?
Maybe coming in here.
Yes.
Amber, this might be what we're waiting for.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
Okay. And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alex Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, when this case started.
Mr. Waters, my recollection is that I sued Alex Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdoch Family Trust, which owned the property where the boat was launched from, and we believed that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdoch, which is Alex's son, but I think those were the defendants initially.
Okay.
And maybe Randolph Murdoch personally as well.
I'm getting all the boxes put together, so we'll have a picture-in-picture here. I have to build it manually and sync everything up. It'll take just a few minutes.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Now, can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday, so the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she In your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
Oh, my goodness.
All right.
This guy has got an ego and a half.
Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
Sure. My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alex's personal lawyer, brought me all of Alex's insurance policies, and so I reviewed them at that time, before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
You know, in a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes, when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right, and when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims.
Let me just interrupt.
Not
Anthony
just the
Fucci
Beach
just pled
family.
guilty.
There were 2 other girls on the boat and 2 other boys, and including Paul Murdoch.
Sorry, Aiden Fucci just pled
and
guilty.
So
no trial.
when I reviewed the policies, it was apparent to me that there was no
They were supposed to pick a jury
possibility
today.
that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court, why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy, and so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusions. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge, is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what
biting his lip this morning.
You were seeking this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family.
That will not happen, Matthew.
And then the hue
There's
and
no
cry as it related to the liability and the Murdochs in particular. And so you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alex's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing what insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
You know, I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer
all the
who
personal
does
injury lawyer
civil
things
work,
right now,
was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference. But
this was a boat crash. Driver was drunk.
2019 of August.
Did you see the defendant there?
Her body for about 8 days.
Did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case."
Okay.
These guys are so arrogant,
what was the
both
point of
them.
that conversation? What was, if you can explain to
Alex,
the court what
that's
y'all
not
were
how I
talking
remember
about?
it.
What is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was. No, 20. September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
Yeah, COVID. The court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
All right. And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Get something marked real quick. Hold on.
This is funny. Two big-name lawyers from neighboring counties, basically, going up against each other, trying to make the other person blink. It was a sort of a game of chicken, but Alex Murdaugh didn't have any. He was holding nothing. His hand was weak. And even though they were supposedly friends,
Show you what's been marked as Exhibit 401.
Don't believe I won't burn your house down.
And see if you recognize that document.
Yes, this is still part of the 404B hearing.
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
Has he got a hat line on? Sorry, has he got a hat line? Seems low, just over the brow. Seems pretty low to wear a cowboy hat.
All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alex said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel, and about a week after I'd filed that motion to compel, Danny Henderson, who again was Alex's personal lawyer, came to my partner, said he couldn't believe that we were going after Alex personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up, and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense, essentially, that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
You have to like, check the couch cushions for a spare million.
That was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever, and so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends that somehow there's a fix on. I think for a long time Alec thought there was a fix on, that he was just a placeholder or a venue defendant. Right. And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alec, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? The analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase, or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that, show me the books to prove that, what was your response from Alex's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. I'll show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alex's responses to the interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right. All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number 1, please.
Well, in as broad terms as
well, let's just read it real quick if we could, please.
All right. List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
Right. And ultimately, what was the Alex defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
Okay. And so ultimately, you filed a motion to compel, is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others. Is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alex's attorneys?
So his personal attorney, as I've said, was Danny Henderson. who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon ultimately. I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case, is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at him and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, you know, the way to, again, like in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, you know, that's what I'm trying to do, is put pressure on him to force him into a settlement. You don't want it disclosed? Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alex's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right. Let me put this up on the screen. All right, if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021, is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah, so in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I'd just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave,
there's the Greg Parker
the
name.
issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time I've said that I'm gonna leave the case in Hampton, but if I think that Alec has fixed the jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes.
I've never seen a witness this comfortable being questioned.
Ultimately, and
almost like he's
while
trying to
you were in
drive
Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
This is still direct.
Into the investigation.
Correct.
It's not personal, Ivan. It's not personal, I promise. Everyone leave Ivan's liquor store alone. Quit suing Ivan's liquor store. He's got an ace in his hand. That's what he's got, and he knows it. I'm going to try to switch video here just for a second. It's going to be a little loud for a second, sorry.
I'm going to show you what's been marked as states 404, 405, and 406 to your for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021?
It's either the 10th or my recollection is the 10th. I know the emails say something different, but and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done, and he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at States 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at States 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right.
Yeah, Vixen and Amber are the same person. Sorry if I let the cat out of the bag there. Yes.
Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as Stage 407 and Stage 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right, so the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alcohol, identification of all accounts. Is that correct?
It is correct that that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that week?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
After the murders happened, let Let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I'd known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
You can watch this
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec, he hasn't done anything, it's Monday morning of the roster, maybe you expect it to be continued, and he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things, but
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
Yes.
Explain that to the court.
He had cancer. I'm not sure if he's
initially
in remission or what. He did have cancer.
Probably say the first week, there was the shock and horror of what had happened, and nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case, so I would have ended the case against Alec.
You would have ended the case against Alec with just...
I probably, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
Roxy just came in with 5 more gifted memberships. Adam Nusky, Tiffany Murray, Jado, Jackie Smith, and Eric Bantner. Congratulations. I'm going to pause this for just 1 second.
You had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
Okay, hang on 1 second. We're going to pause this just for a minute. This feed is a few seconds ahead of all the other ones, so I'm going to just slow it down, and there we go. I think we're good. We're synced up here. That way I can do more box in a box and follow what I want to. Roxy, thank you for the gifted memberships. You were super generous this morning. Appreciate you.
Did you receive any call or any communication from the Satterfields about any recovery in the Gloria Satterfield death?
At some point, my recollection is it's early September of 21, Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement, and he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Try to fix the audio here. Just 1 second. There's just too much noise on that one. Okay.
Nothing further this time, Your Honor.
Nothing further. Stopped right there with Eric Bland and then said nothing further. And it looks like Dick is not doing the questioning. Somebody's McMuffin wrapper. Empty water bottles. There's trash all over on that. That is awful. There's trash all over on that bar.
You testified at length to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was underinsured for this incident, and you're going to go after his personal assets, and that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insistent that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from him.
Sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99, but if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money.
Let me tell you what I think is happening.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
Prosecution inserted Eric Bland in. They've got his name in. They're not going to go into everything they've got now. But if this gets in front of the jury, I think they will.
There was an urgency because
so I think
John Tiller
they've said, hey, we brought him up
about a year to
during the in-camera.
And we were going to try that case.
But they'll go into deeper depth on that one.
Early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like
financial crimes, 99 of them are life in prison without parole, maximum penalty.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex, had you?
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment. There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that.
This is
claim
Mark
to the
Tinsley.
court. That wasn't before the court, was it? That was just a
It's a
conversation.
personal injury attorney
with John Tiller.
representing
That's
the
the conversation
victims.
that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
More than likely, I mean.
And the
more than
hearing that
likely
was,
life in prison.
that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard, is that correct?
Correct.
There were many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had one or two motions. Some of the motions got resolved, one of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practiced in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video for mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter, and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
Pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12,
Sounds
interrogatory
thorough.
number 13, interrogatory number 15, interrogatory number 18, it seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. No,
Was it either or?
Yes. Nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic, do you?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up.
I really hope this comes in because I'd like to see the prosecution questioning, the line of questioning of this witness in front of the jury, where they will go into, there'll be more set up.
But this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental request for production. Is that correct?
It is.
And if we turn to...
and 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because 9 and 10 asked Alec about...
So, sir, no one's
there was no
asked you
question.
about
Okay.
9 or 10.
Yeah. That's the only way we
We'll
can
get to it.
smack
First,
back at this guy.
let's turn to answers to first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B?
B. It's the first page of what's Exhibit B in here. It's right there, that's it. It's the first page after the motion, so it'd be page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts, and then you don't have to highlight or expand this stuff.
Denise,
All
thanks for
stock,
being
and then
here.
number 2, all stock certificates, and we go to the next page. All property and interest of property of every kind whatsoever, from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, etc. Profit sharing plans, pension plans, etc. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you?
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
he granted this motion?
I think so. You want to see the order?
Yeah.
Oh my goodness. Boom.
It's the record, October 7th, 2021.
Oh my goodness.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing
That's
if
right.
necessary.
Which means...
If Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
Only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied, or it's premature.
Would you say granted?
Well, I think that's what it says. It's a practical matter when parties have discovery motions. Oftentimes, like Alec has, in his own statement, said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge.
This guy's right.
So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
It's too bad the jury didn't get to see that. They won't get that same effect. You can't recreate that scenario in front of the jury.
2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before let me finish.
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit, I believe.
And this was like a dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action, yes.
Okay. And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very quickly.
I understand you don't want to acknowledge what I've handed you, but...
Sir, I asked you what the ruling was on the motion to compel from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Alec is that Alec had, and his lawyers had, 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight-up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the argument.
You presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front of the judge.
So you're saying the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is, how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alex lawyers knew what the evidence was, they knew what the amendment was going to be and the allegations, and he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that appears you're suggesting now.
And again,
this is so spicy.
The gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up, and we saw the one that asked for financial information was deemed premature.
Not at all. You know what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements now. It would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks, there's no way these checks are going to Forge, there's no way that this money should be transferred.
And even if, hypothetically, had this hearing on the 10th, and you got a different ruling regarding Alex Murdaugh than you got against Parker's, that for some reason it's not premature to him, isn't it true all you would have been all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, you know, that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, you know, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right, you just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it. So, I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
Wow. The back and forth.
You wanted pre-trial ability to pay discovery to inform whether or not to accept a compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. It would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. But that's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case.
And then I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office, or was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Beg your courts and buildings.
Wow, it's getting a little spicy in there. Lawyer versus lawyer. They know they have all the tools. These guys are both very good lawyers. One happened to get caught asking a question that he didn't realize the other guy was going to answer that way. But the breast pocket, yeah, I've got the court order right here, ready to go, printed out on 20-pound paper. Yeah, that was hilarious. You want me to read it to you? Oh wow, it was spicy.
If the hearing had gone forward on June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen...
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome do you would you have expected?
Well, now I know that Alec was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't...
Let me just make it a little simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to issue.
Break it down. An order would have issued at some point later, and what, if it were granting your motion, what would that order say?
I think it would say the same thing as...
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
It's a voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten you've gotten his, would the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alex.
Right. Would you have gotten, what, a financial statement?
No.
The court would have ordered every account detailed listed to you, all his personal accounts, just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I've told you that a couple times.
Right, to subpoena.
Sure.
And,
but that's different
and
than
that would have been resisted,
me.
and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
That's what the defense is trying to say.
What was resisted?
That there wasn't a deadline.
If you got the names of the banks,
there wasn't pressure on Alex.
Subpoenas, there would be motions to quash
this would be months of arguing.
Well, you're right? Speculating the same as you're asking me to speculate. I'm trying to talk to you about
the prosecution
what the
is
judge actually
saying
did.
He had this pending
what was
date
actually
where
in front of the
everything was
judge.
going to be
I
blown
get
open.
you don't want to talk about that, but we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not
dial it back just a little bit.
Whether or not I was entitled to
the jabs.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
I agree with him. I think that's what I hear when I hear that the witness got the last word. Wow. Oh man. The defense definitely wants this to look like there was not a deadline, that there was not a pressure that Alex's world was coming to everything in his financial life was coming to a head. But the prosecution is saying there was. This was, he had this order. He had to disclose it. His books were about to be blown open, wide open to the world, basically. And all this would be made known. And that was his motive. That's what the prosecution's saying. Defense is trying to say, no, this had been argued for months. This is just preliminary stuff. The judge wouldn't grant it.
So just, maybe we can agree on this.
No, I doubt it.
The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying the fuse was lit when you were going after his assets, and that fuse was going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money.
Okay.
Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right, but it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. No further questions.
That was the smallest of win.
And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection, Your Honor.
There's only one.
Objection, Your Honor. Leading.
Don't lead the witness. If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
That's what the state wanted out.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Alec was broke and you didn't believe it?
exclusively for that reason.
And you believe that if he was broke, he had to be hiding assets?
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten.
From Alec?
From Alec.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol.
There's a little descriptor of the videos that are coming.
Only on the documents that were filed.
Sir, were those issues, though, in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed these are the issues.
This is the 404B. This is just the financial information. That's the purpose of this hearing. So there's other stuff that even this witness may be able to testify to that probably won't come up right now.
Stage 407, so you can recognize that.
Yes, this is the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Whatever that lawyer's name was. He knew what that lawyer's name was. Oh, man, they do not like each other. No drinks after court today between the two of them.
And that's from October of 2021, is that correct?
It is.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Edisto?
It was an option.
As well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor.
Nothing further.
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Step down.
They said nothing further from the defense. We've been beaten badly enough. That was very interesting.
Your Honor, a couple things. Our next witness would be Ronnie Crosby. Just to let the court know, the court indicated Friday that we had kind of already established, as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. Again, and thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself at, in prep in the evening or whatever, privy to that particular conversation.
Any other comment about the attorney attorney-client privilege issue, Mr. Griffin.
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call the
right.
Some of the folks
law partners
as witnesses who were there when you were there, along with Mr. Murdoch.
And so it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdoch about, and that's where this is going, or if the question is Mr. Murdoch talking to Mr. Crosby, and is that privilege? Or Mr. Murdoch talking to Mr. Lee Cope, and is that privilege? I'm at a loss here.
I don't know either, but I say as far as the law is concerned that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses and you want to call them as witnesses,
that's not what he's asking
if
for.
There are necessary
he's asking
witnesses
for what he heard in the conversation, which would be hearsay.
All right, thank you, Your Honor. We would call Ronnie Crosby to the stand.
Okay, Ronnie Crosby, is this a law partner? One of Mr. Murdaugh's partners? If so, this would probably be a hostile witness. Very short break here, just a little stretch. Okay, the judge, the way he's answering that question, I don't think he's getting at the meat and potatoes of what the prosecution, what Creighton's trying to do. Creighton wants to call a witness to say, tell me what Murdaugh and his lawyer were talking about when it was not a privileged conversation because you were there. And the judge is saying, if you want to call the witness and ask him questions, he's not protected by attorney-client privilege because that wasn't his attorney. So I think you're going to have this witness on the stand, and you're going to hear a lot of hearsay objections, and the judge sustained them. That's my guess.
Left hand on the Bible. Do you affirm the testimony about the report in this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Ronnie Crosby, Crosby, C-R-O-S-B-Y.
Mr. Crosby, how are you?
I'm okay.
All right. Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alex Murdaugh?
I am.
You see him in the courtroom here?
I do.
And where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
On
nickname Bing.
And again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury. But I do want to explore a particular meeting. Were you present for a meeting in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alex's brother John Marvin's place, which is not very far from Alameda that y'all been talking about, and I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him, and so we gathered there. I was present, Mark Ball was present, Lee Cope was present, John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but did the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day, and we were there for support, and he went over the events of that afternoon, or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together, and I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were being, for me to hear them, I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdoch. They did have some private conversations that the rest of us were not privy to, but
wow.
So there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Sorry.
Correct, and this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting or this discussion, have conversations with Alec about his activities the night of June 7th, 2021. They were outside of this, is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on, because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, we had multiple conversations, as you might expect, all of us in a group, and there may be pieces and parts, but what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Okay. Your Honor, I don't believe I have anything further for purposes of this now.
Debbie, shh, don't tell people.
Anything further?
Yeah, please, court.
Let's see what happens here.
Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster, could be interviewed by SLED. Is that correct?
That's correct. The purpose was to that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed, and Jim, now that you speak of it, I do think that while Mr. Randolph did not come into the meeting, he and whoever brought him over did come by. Right. There are two that I'd forgotten.
Yeah, and
then went back to Alameda,
where he died within hours of that, right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
Okay. And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present?
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alex some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. Do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him.
Well, did you, or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? I mean, did you give him that warning?
Mr. Griffin, we're all lawyers. Other than John and Buster that were there, I don't think anybody needed to say that, and it never crossed my mind that when we were sitting in a room and all of us were talking that we were somehow representing Alec.
No, I understand that. And it was, okay.
And nor would I ever do that, because I don't practice in the area that you do.
Right. But it was clear that Danny had an ongoing attorney-client relationship with Alec, is that right?
He did. With regard to the boating accident, he was Alec's personal counsel in that.
And Danny had sat in the initial interview that was conducted by Sledge Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know?
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, for support, because.
Well, can you say
Agnes,
for
this is a
certain
former
that
law
whenever
partner
you
of
heard
Alex Murdaugh.
Conversations from Alec about his recollection of what happened on the 7th, that
Mr. Crosby, I believe his name is,
that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
There were.
That you're referring to hearing conversations with Alec in the group about what happened on the events of the evening of June the 7th. And my question to you is, when Alec was making these statements, let me make it clear, were they just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where John had walked out? When I heard any specific thing, I can't tell you that. I couldn't catalog because I said it's a little bit fluid. People come and go, and law enforcement arriving outside, and people walking out to greet them. I mean, it wasn't like the sled agents just showed up and it was some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please.
So they're trying to see there was some sort of attorney-client privilege because all of them were attorneys, and thus, and it's not going to fly. The judge is not going to say that. Clearly the witness right here said,
Questions I have, Your Honor.
"I don't even practice law in this area. There's no way I would be his attorney for this."
This issue.
This particular issue, no. I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we, in discussions with the defense, that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all of this through. And I know that we're butting up with the jury being here shortly, but...
they arrive in 10 minutes.
Yes, sir.
Anything further on this issue regarding...
all the 404B?
Evidence of other crimes?
Yep, that's all 404B.
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but that would be it. As again, for in-camera proceedings before Your Honor, to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it. That's the side of the road.
We'll take a break of about 5 minutes, and I will announce my decision regarding this other evidence.
Vixen, Amber, are you tied up right now, or would you be able to call the burner phone if I let you through? Mangy Coyote, FLA vacation is over. Returning to recover at its regularly scheduled programming. Good to have you back. Quite a long face, Alex. Okay, so this was basically what we heard was the end of the 404B testimony. That we're done hearing everything. The judge now gets to consider it. He may rule at the end of this 5-minute break. The one thing he has not or will not be considering is what will be allowed as far as the side of the road incident. That side of the road incident is what the state says, where he hired a hitman to shoot him in the head. It was basically it was going to be a self-harm. Unalive himself using a hitman, because if he did it himself, the insurance policy would not take effect, and his buster would not get anything. But if somebody else did it, then it would be in effect, and buster would get the settlement or the payout. So the judge has not heard that yet, so we don't know if that's going to come in yet. Can he make the decision in 5 minutes? I think he's probably made the decision before it started this morning. I think he knows what he's going to do already. Did you dance while you were being a chaperone? No, Debbie. I've hurt my knee. I can tell you a story. I picked up a safe, and it was a small safe. But I picked up a small safe and had to carry it down some stairs. And about halfway down the stairs, I realized this probably was a 2-man job, and it was too late at that point to do anything other than continue down the stairs. And there was no popping, no hurt, no falling, nothing. I made it all the way down the stairs. Everything was fine. But now my knee is so sore. And it was all I could do to limp to a chair in the corner and chaperone from the corner at the dance over the weekend. But I think Amber's probably in a meeting right now. We might need more than 5 minutes as well to have her go into everything. See, work is interfering with my day. I missed this guy's testimony. Was it good? Yes, I think it was good. I I think it did establish that there probably was not a attorney-client privilege from a legal perspective, which, and it's a detail, but I think he established the detail that the conversation that occurred there was probably not protected by attorney-client privilege. Whether or not that gets in, I mean, it sounds like the judge is going to let it in, but the actual, what he overhears, we're going to see a lot of objections there, especially, because it seems like the defense can't remember, the attorney can't remember what they talked about. He's like, what, did we say anything there? Did anything come out? Bella says, I can ship my walker to you. I retired it 2 weeks ago. No, I'm hoping to do better. Today my knee is a lot more, it's in better shape. But you know how when you hurt your knee, like all the leg muscles and your calf muscle and everything else, how that like compensates? That's what's sore right now. Is everything else because of this. But so I'm going to get feeling better here in a couple days. They know what was talked about. Is that what they're worried about? Jen Presley, welcome to the gallery. Thank you for becoming a member. Appreciate you very much. Please do take your seat, ! Seat in chat. Will get you right up to the front row where you can sit with all your friends. The view is great up there. And once again, thank you for supporting the channel. Ice. Yeah, I should ice. I'm doing the anti-inflammatory right now, but I should probably get like a bag of frozen peas on my leg or something. Judge will allow testimony. Objections will be denied, says Andy Cutright. Aiden pleaded guilty. Yes, he did. He changed it, right? It was supposed to be jury selection today. And Aiden Fucci, like Gucci, did change his plea to guilty, which I think was the right thing. There was so much evidence. I mean, talk about an open and shut case. I don't know how he could have imagined that anything other than him being found guilty would occur. But maybe, I'm not sure if there was a deal on the table that he took or something else. We'll have to hear for that. Did I see the balloon link? Yes, I did. Thank you very much. That was funny. Interesting take, for sure. We followed the balloon a little bit on Saturday, right as it was getting shot down. And that was a fun little stream that I may or may not have worn a tinfoil hat. And just to protect myself from, anything that might have happened. All in good fun. Let's see. Crosby, not Cosby. So it needs an R in there. Douglas, do you want to send me a new chat that has, the witness is done now, so I guess we can unpin it. It's too late. It's too late. Yeah, if any of you want me to pin a message regarding who the witness is, as long as it has the accurate information, as well as it can also contain something funny, like if we have a nickname for them, you can put that in there as well. I'll pin it to the top of chat while they're testifying. But if somebody sends a more accurate description, then we'll switch to that one. Not much room up here as we have a few that fell over sleeping. It's an early morning, Christy. The front row is a little crowded. Next time you can show the kids how to dance. Debbie, I will tell you, maybe this is too much information, but my son, who was present at the dance, participated in a contest, and there were probably maybe 200 youth there. And this contest involved lip syncing and dancing, and he won. He was the winner, and it was not close. And I will tell you that he did not get those skills from me. Let's see, tweets all over the place. Okay, we'll probably. I hope we get to see a lot of these witnesses, especially the attorney that pulled the judge's ruling out of his pocket. That was fantastic. I might clip that and put that in a little short. YouTube is bugging me. They want me to make short videos, like the vertical ones. So I think I might clip that and try to put that together just to see what happens. Lots of people watching this trial today. A whole ton of people. Yeah, he won a box of candy. It was not like a college scholarship or something that I would really be proud of, but a lot of people liked watching him perform. Richard says, "Little Miss, if you considered an exorcism for the devil dog, her dog that chews on everything." Rhonda Hughes, welcome to Hotel California. You can check in but never leave. You're a member now, so you're stuck. Jen Presley is a member as well, and she's also stuck. We just wrap our arms around you and squeeze tight and never let go. Last witness reminded me of Elmer Fudd. Jimmy, yeah, he was I think he was a reluctant witness. He did not want to be there, but at the same time, he is suing Alex Murdaugh because he's one of the people that Alex stole money from. All this embezzlement over 10 years, that was basically money out of his pocket. It was money that should have gone into the pot and at the end of the year been split among all the attorneys. Let's see. I've not been faithful to these last days of dress rehearsal testimony, but I'll be interested to see how these two parties re-perform these testimonies. I think it will be a bit for next. If you missed these last couple days, all the 404B testimony, if it gets allowed in, I think we will see, for the most part, a better production of all that information, although a slower production. There will be more in-depth questions. There will be more background. And there's going to be more probing at the answers and spelling things out for the jury. So it's going to take more time than we saw it. It's probably going to take about a week, a full week to cover what we saw. Plus, there will probably be another witness or two. But that's I think if it comes in, you'll get the full effect. You won't miss out on anything on that. A few of you are all these people seem like snakes. Yeah, a few of you commented that that these defense witnesses or defense attorneys are slimy. I will say that that I had that opinion, and the more I do this, the more I value the service they provide, because of my personal belief in the importance of having that you're innocent unless proven guilty. There's this presumption of innocence, and you have a right to a fair trial. And honestly, I believe that that the state, just because you did something, I believe that the state should have to prove it. That we shouldn't be putting someone in jail if we can't prove that they did it. I think that's important for the process. And so, sadly, that does result in people who commit crimes and don't get punished for them because we can't prove it. And as frustrating as that is, and it sets my teeth on edge, at the same time, I think that it's necessary to have that to have the best process we can. Did the last witness know Alex was stealing at the time of the murders? No. Bite me. They didn't know until, well, let me look at the timeline. I would say yes. Yes, because they had said they'd forced him out. They knew that something was going on, that he had stolen from them. But he hadn't actually been forced out. I don't know the date that he was forced out, disbarred or anything. So because of all the stuff that was happening in his life with his dad getting sick and everything, that sort of delayed things. We'd have to look at the timeline for sure and see. Defense attorneys are absolutely critical to protecting your rights. I agree, Andy, they are. And as slimy as they are, as much as we don't like seeing it when we've got someone who's clearly just a dirtbag of a person, I believe it's the right thing to do. And somebody needs to do it, and they need to do it well, because there are also people who just happen to be in the wrong spot at the wrong time that might it might be a convenient solution for someone to say they're guilty, but they're not. And we need to be able to have that, a defense where they're presumed innocent, and the state has to prove it. Tons of information in Discord about the timelines and everything else. So if you have not joined Discord, go ahead and click the link there in chat and follow. There's a process to roll up that basically gives you permissions in Discord. It's just a quick little thing. You do it once, and then you're good to go, and then you can access just a wealth of information over there. That Lil Miss and Toxic and Amber and a couple other people have put together. Let's see. I did send a link to Recovery Addict showing that Alex Murdaugh was asking people to put money on someone else's commissary account. Really? So this is going to be recent because that's while he's in custody. Let's see what we got here. Debbie, you sent that? Is that the part of the Murdoch podcast? I think it was in the podcast. Okay. It was in the phone calls from jail. Yeah, I don't know what that was about, what he was trying to do there. I haven't chased that down. There's so many little threads that you want to pull at, and some of them are just bits of fluff, and others will unravel the whole sweater. And so knowing which string to pull, I love the analogy of the fuse, though. The fuse had been lit and it was burning, and this hearing, this financial hearing, was going to just put a whole bunch more oxygen on that fuse. Thanks for the surprise Saturday coverage on the balloon. That was fun, Carol. Glad you could be there, or at least catch it on the replay. The reason he'd want money on other people's books is they are probably taking any funds he gets on his. They can't take it all. They can't because he hasn't. See, I don't know what settlements are against him already. Does he still have like a pending outstanding balance to pay on some? I know he's got some court cases, but I'm not sure if those ones have been settled and he owes or not. Sirens in my neighborhood. Be right back. Have to be nosy. Good luck, Ann. Hope everything is well. They can only have $60 max, so the guy he was using did not have any money on the books. I think he was gambling per the podcast and phone calls. He's gambling in prison or in jail? Man. This is also something that came up a little bit with Aiden Fucci when he was in jail, because he ended up having a whole lot more commissary than he should with how much money he gets, and they had to figure out what was going on and figure out he was like bullying people and everything to steal their stuff. Let's see if we have a ruling here. The judge has some papers to read.
This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules.
This is it.
Of evidence, and also under the theory of res geste. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted.
Boom. It's coming in.
Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And before admitting this evidence, the court must first determine if it's relevant. Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence, and the court is to conduct and required to conduct an analysis under Rule 403, which weighs the probative value versus the prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time. The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdoch concerning the improper disbursement of fees in the case of the estate versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife Maggie to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, had been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances.
Sounds like he's allowing everything in.
Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as a main depository for a substantial, if not most, of the misappropriated funds. We heard testimony from Attorney Chris Wilson about confronting the defendant about the missing $792 and
Missed $1,000 on that one. $792,000.
Sum to him owed of $192,000 was later discovered. And that testimony or that confrontation took place on June 7th. Mr. Murdoch later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother.
A lawsuit against himself. He really did say that.
The housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case, and when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from Mr. Carson Burney from the State Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh, because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this case, since the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge.
So you're saying it's not prejudicial, overly prejudicial.
Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but it's more probative than prejudicial. As to res geste, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and the looming exposure of this criminal activity. And the state contends that that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime for which a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred, then that evidence is admissible under the theory of res gestae or res gestae, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res gestae, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged under the theory that the state is seeking to prove, that proof of it is essential to complete the story. And our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res gestae. Further, in State v. McGee, the court held that where res gestae, evidence of res gestae or part of res gestae is properly admitted, then no 404B or Lyle analysis is reached. However, as to the finding of admissibility of evidence, which I have done, and the finding of it within the res gestae, I've nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order granting the state's motion later today.
Okay, he did not write that during the break. That's more than 5 minutes of writing.
Are we ready for the jury?
Which means he made this decision ahead of time, probably before the weekend.
On Your Honor's ruling, I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence.
Okay. Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction.
How limiting? It's reviewing what the limit is. It's probably not going to be as limited as what they've asked for. Creighton just got his copy. So defense had to prepare for this. They knew that this was coming.
Schedule will probably be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed limiting instruction?
He's like, do you know what they're asking?
Right now, Your Honor.
You might want to look at this. He's probably going to object. I think in front of the jury, the judge is going to be a lot more careful with those jabs back and forth, and ask them to, keep that on the playground and be a little more formal in the courtroom. We know they don't like each other, but you'll probably see a little bit of that, but it will probably be objected to. All right. So everything's coming in. Yes, it will be an appeal. It will be an appeal, but this case is going to be enormous. And I was listening to a couple legal minds over the weekend, and they said huge cases like this, just on their size alone, appeals courts are hesitant to pick up just because they're so massive and convoluted. And it seems like the one person said that, I forget who it was. Might have been self-defense law or somebody who said it. Might have said that he feels that the prosecution is trying to appeals-proof their case by just making it so enormous, so big. You think AM should change his plea now and just throw in the towel? I like the jabs. They were fun. And it lets us see a little behind the scenes, especially with, these are two lawyers, or there are two sides that have been battling.
I need to give this after the testimony or before the testimony?
Before the testimony is offered, Your Honor,
Right.
from a financial witness.
That's fine, Your Honor. I would just, as to the specific language here, obviously it has the next to the last sentence, as it's being allowed, and it makes a specific representation about the state. It only refers to motive, not identity. It's more of a 404, not a res geste. I don't know that sentence is necessary. The last sentence, I think, also has a typo in it. But I would...
They look over it. Who typed this?
Generally, though, I have no problem with this charge, and I have no problem with it being given before such financial evidence is received.
You've indicated those witnesses will testify later today or tomorrow?
Probably not late today, but certainly tomorrow.
All right. Well, you have an opportunity to submit your own proposed limiting instruction or to confer with the defense counsel and see if you all agree.
South Carolina has the death penalty, but they are not pursuing it in this case. So the greatest penalty he can receive would be life in prison without parole.
I mean, you have the other question of race,
which he's also facing with about 99 financial charges, life in prison without parole on each of those.
For race geste testimony.
Buster's girlfriend was in the courtroom this morning.
And I guess I understood the scope of the court's ruling to go beyond res geste or gesti and to include prior events he wasn't confronted about on June 7th. Now, if the court's ruling is limited to
Buster's girlfriend's right
the
next
confrontation on June 7th and about that transaction,
gentleman with the beard,
then it would be res geste.
It's not limited to June 7th.
She's not the one in the tan top.
June 7th also includes race geste, but the ruling includes all evidence of financial crimes that may likely have led to a motive, lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record.
Yes, sir. I understand.
Showing no disrespect to the court.
No, I understand. Okay, we're ready for the jury?
State's ready to proceed, Your Honor.
Bring them on.
Bring them on. All right, so here we go. We're not going to start with the 404 stuff quite yet. That's going to be a little later. So we've got some other evidence first. It'll be interesting to see where we pick up. Yes, Buster and his girlfriend are there. She sort of hides behind somebody. I don't think she likes the direct view of the camera, so she positions herself there on a regular basis. Let's see. Cachette was saying, can I get an anti-shout out to mean bosses? Cachette, if you want to just go ahead and take the live stream over to your boss, I can talk to them directly. Just tell me, is it he, her? What's the gist of what you want me to call him out for? And I'll go ahead and do that for you. It may not be good for your employment status, but I'll call him out. Let's see. I'm going to runs. Anybody want any? Oh, quick run.
Thank you.
Jury's
Good
present.
morning.
Good morning.
It's right at noon.
It's lunchtime. Let's break.
Well, 11:58. It's still morning. We embark on day number 11. Call your next witness.
Please, court. Yes, sir. From the state of South Carolina, we now call Miss Michelle Smith to the stand.
Michelle Smith. Is this a relation to Stephen Smith? I think they'll go through with the financial crimes, especially if there's any money or estate available, because they all deserve some sort of compensation.
Left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Yes. Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
See if the demeanor changes at all today.
Michelle Shelley Smith.
Take a deep breath.
Yes.
What is your first name?
Michelle.
Spell that, please.
M-U-S-H-E-L-L.
Where did you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
Is it Michelle with a U?
U, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Ms. Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you won't mind just pulling this up a little bit and speaking into it.
Okay, thank you.
Thank you. Go ahead.
I was born in Hampton County. Have 4 grown kids.
Louder, Ms. Smith.
I was born in Hampton County, 4 grown kids, 8 grands, and I worked for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable.
We just want to hear. That's what it is. It wasn't comfort.
You said you had 4 adult kids.
Yes.
And then you said 6 to 8 grands.
It's 8 grands.
8 grands. Okay. And raised where?
Hampton, South Carolina.
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Ms. Smith?
Got married, raised my kids, and that's what my profession. That's it. Mm-hmm.
And that is the hardest profession, raising children.
Yes.
You had 4 kids.
4 kids.
And when you were raising them, you were raising them, taking care of the family.
Mm-hmm.
And are any of your family here today?
Yes, my brother and my daughter.
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up? Is that your brother?
Yes, that's my brother.
And who else is here?
My daughter, Rochelle.
Miss Rochelle, will you stand up? Thank you.
I've never seen that before.
They here supporting you today?
Yes.
He's trying to let the jury get to know her and get to like her, which means we're probably going to get some hard
other than
testimony.
raising a family, which is the hardest job, were you doing anything else during that time period?
No, till 1995. I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you were raising your family?
Usher, kitchen ministry.
Kitchen ministry?
Mm-hmm.
Okay.
Yes.
And how long did you do that?
Oh, all my life, church.
Are you still doing that?
Yes.
Okay. And you don't have to name your church, but where's your church located?
Fairfax, South Carolina.
So at some point after your children moved up in years or got older, did you start another profession?
Yes.
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
Private home care.
I'm sorry?
Private home care, caregiver.
How did you get into that?
My aunt.
And was she in that business?
Yes, she's an LPN. Yes.
An LPN?
Yes.
Licensed practical nurse?
Yes.
This is the blue raincoat.
And when did
right?
you get into the home care business?
Probably about 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay. Tell them when you started with the school.
It's school in 1995, that's correct, 1995.
In what school did you start with?
At North District Middle School in Warrenville, South Carolina.
North Central Middle, Varnville?
North District Middle School, yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change locations?
6 years later, I went to Wade Hampton High School.
This lady took care of his mom, I believe.
Don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School.
So total years in the school system is what?
28 years.
And you're still there?
Still there.
So you started home health care while you were still teaching school? Or
No,
still going to school?
Going to school, working, food service.
And will you please tell them, you said your aunt got you a business. Were you working with one family at a time, or did you have?
Different families at a time. Okay. Different families.
And how long would you stay with the family once you became their caregiver?
It all depends on how long, if they're deceased, I will move on to someone, another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said there's a job, and she let me put me on that job.
Okay. So to give the jury an idea before we get to this case, your schedule would be what when you were still working at school?
Yes,
and
at school.
caregiving?
Yes.
Okay, so what was your typical day like?
My typical day, I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
Can you tell this jury, Ms. Smith, how it came about that you started working for the Murdoch?
It was a job opening. I think one of the caregivers mentioned it to me, and I said, yes, I'd be interested in going. And now that's how it started.
Okay. And one of the caregivers mentioned your name. Do you know who that was?
Yes, sir.
Okay.
Miss Barbara Mixon.
Miss Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up?
Yes.
And can you tell these folks when that was? When did you start working for the Murdaugh family?
It was October of 2019.
And what was your role as a caregiver specifically for the Murdaughs?
Miss Libby, taking care of Miss Libby. Miss Libby.
Okay. Was Mr. Randolph, I knew him as Solicitor Randolph Murdaugh, but was Mr. Randolph, was he there living when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeda?
Yes, Almeda, yes.
What was your primary job as the caregiver? Were you there to take care of the solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby.
Okay. Did you also ever tend to Mr. Randolph's?
Yeah, every now and then. Mm-hmm.
But your main focus was Miss Libby?
Miss Libby, yes.
From October 19th up to June 21st, Ms. Smith, and I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury there, but did Miss Libby's condition get worse?
Yes.
And she's suffering from something that affects all our families, it's Alzheimer's?
Yes.
And that got worse from the time you started until June?
Yes. Mm-hmm.
Well, in June of 2021, how would you describe Miss Libby's condition?
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No.
All right, specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20, I will leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go back to the school.
So was that the shift you were working for the Murdaughs?
Yes.
Primarily?
Yes.
An 8 p.m. to 8 a.m.
Yes.
shift? When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes.
You would rest?
Yeah, rest for a couple of hours.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes.
Well, ma'am, I'd like to take you to June 7th of 2021. If you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh on June 7th of 2021?
Yes.
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital, was he there when you got there on June 7th?
No, he was not.
Okay. Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
Okay. And that's the time you were there?
Yes.
And you're never late, are you?
No.
Okay. And is somebody waiting to leave for you to get there?
Yes.
Okay. And this night, who was there?
It was Miss Barbara Mixon, I'm thinking. I can't remember. I think it was Barbara.
I'm having trouble
I'm sorry.
understanding your words. Can you speak maybe louder?
Okay. Yes,
I know you can't change your voice, but
yes, sir.
a little louder, please. Or closer to the mic.
Can you tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver, and this was what time of night?
8 o'clock that night.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No.
If they're sleeping, do you want to wake them up?
No.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, hey?
You know, just come in with, change her, if she need to be changed or whatever, like that.
Make sure that
She's
dry?
She's dry, it's okay, yes.
And so where's your desk, or what's your position when you're there, when you're in her room, Miss Libby's room?
Yes.
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
In a recliner. Have a recliner, sit there.
And is there a TV in the room?
Yes.
Okay. And is the TV usually on when you're there with Miss Libby in the evening, or is it?
Yes.
Okay. Was it on this night?
It was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Says, a game show.
Say it again?
American Says, the game show.
Okay. How long has that been on?
It's stays on, it repeats. It's afterwards repeats itself.
What channel is that on?
The Game Network show. Channel, excuse me.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes.
Okay. Do you remember what time it was? Approximately.
The game show was on, so it had to have been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
Yeah, somewhere up in there.
Okay. Is it fair to say it was later in the evening?
It was late in the evening, yes.
Okay. And you had worked that schedule for that 8 p.m. to 8 a.m. shift for how long?
2 years.
2 years?
Mm-hmm, 2 years.
These questions are showing that she has a good
Was
memory
it
of the
unusual to
events.
see Alex Murdaugh at that residence that time of night?
Yes, on my shift, yes.
And that's the only shift you'd work?
Yes.
So the 8 p.m. to the 8 a.m. shift, it was unusual to see Alex Murdaugh there visiting, correct?
Correct, yes.
Had you ever been over there before that time of night?
I think different off and on, it all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house?
Yes.
What phone did he call? It's a terrible question. I mean, was it your phone, the house phone?
The house phone, the house phone.
Okay. And when you answered the house phone, what did he say?
He was outside. They let him in.
He was at the house?
Yes.
Right outside the house?
Yes.
And he called you?
Yes.
And he said, let me in?
Yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there at the house?
Yes.
You let him in?
Of course, yes.
Okay. Do you remember what he was wearing?
Shorts and a t-shirt.
Do you remember what kind of shoes he had on?
Those cloth shoes, like Sperry's, that type of material. Like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, to me, yes.
And you said something called Sperry's?
Something like Sperry's, that, you know, that kind of, but it was cloth.
Okay.
That kind of, yeah.
Wasn't boots?
No, it wasn't boots, no.
And are you familiar with tennis shoes?
Yes.
Was it tennis shoes?
No, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes.
Did he have any socks on?
No.
This is Mrs. Smith, the caretaker for Alex Murdaugh's mom.
Tell the ladies and gentlemen of the jury,
I think canvas is belt type shoes. I think that's right.
could you describe Alex Murdaugh's demeanor on June 7th when you were there with him and his mother Libby? How was he acting?
Like fidgety. This came in, you know.
Speak up, please.
Fidgety, I'm thinking it's normal.
What did you say, man?
Like he was fidgety, like, yeah.
Fidgety?
Yes.
Is that what you're saying? Okay. And did he tell you why he was there?
No, he just came to see his mother.
Okay. Did he talk to his mother?
But she was asleep, yes.
She was asleep? Okay. And what did he do? What did Alex Murdaugh do when his mother was asleep?
He came and sat on the bed, because we was asking what I was watching. I said American Says, I said the game show.
Did he say anything to his mama?
We said, hey mom, how you doing? You know, just came to check up on you, yeah.
Did he say why he'd come to check up on her?
Because Daddy was in the hospital, you know, called him Hansel, yeah, was in the hospital.
And in your opinion, as being there, her caregiver, did she even know that he was there?
No.
Objection. The objection's overruled.
The jurors are hearing this.
No?
This is the first witness the jurors are hearing today.
How long did he stay in the room with y'all?
This is state questioning. Direct.
When I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
No, he was laying on the bed.
Did he have his phone with him?
Yes.
Was he looking at his phone?
Yes, he was on his phone, yes.
I'm sorry, ma'am. What?
Yes.
After that initial conversation, you said he said, I'm here. Did he have any other attempt to have any other conversation with Miss Libby?
No.
Okay. Can you hold your hand out? Did he ever hold her hand?
Yes, he did hold her.
Did you talk to her?
Yeah, she was in the bed, yeah. Yes.
And her condition then was what?
She was, you know, sleep off and on, sleep.
how long did he stay there?
Judge, ask me.
I forgot.
20 minutes, about 20 minutes.
$20.
About 20 minutes.
Okay. What happened after that?
He left.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Ms. Mixon?
Yes.
Okay. Did you learn what had happened at Moselle?
Yes.
At some point after that, did you get a call from a family member? I really don't know who it was, but
Yes, yes,
do you remember who it was?
yes.
Okay, who was it?
It was Randy.
Randy Murdoch.
Randy Murdoch, yes.
Alex Murdaugh's brother.
Yes.
And as a result of that, what was were you expecting people to come over after that?
No.
After that phone call, were you expecting people to come spend the night that
Yes.
night? Okay. Who? Who was going to come over?
Randy told me John Marvin, Buster and his girlfriend, and Alex.
John Marvin, Buster and his girlfriend, and Alex.
Yes.
Okay. And did you, in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you got a call from Mr. Randy saying they were coming? Did they come?
Yeah, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No.
Did he ever come looking for glasses?
That morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
And Mr. Randolph, or Solicitor Randolph, died shortly, a couple of days after that?
Yes.
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
Yes.
And were you happy to do that?
Of course.
And do you remember the day of Mr. Solicitor, I'm going to call him Solicitor, that's the way I know him, Solicitor Randolph's funeral?
Yes.
And I've been reading through all this stuff here. What's a repast?
A repast is when everybody come back after the funeral and eat.
Everybody comes back and eats?
Yes.
Well, after the funeral, did people come to Alameda, sort of like a visitation after a funeral?
Yes.
Okay. Did folks come over there then?
Yes.
Okay. And was the family there then?
Yes.
And during this repast, visitation, where were you? What was your job during that, or what were you doing during the visitation?
I was in the room with Miss Libby. It was back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes.
Okay. Tell the jury about that, please.
He came in the room, you know.
You'd speak up, please, ma'am.
He came in the room and spoke like he always do.
And what did he tell you?
That he was at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house?
Mm-hmm.
When?
The night of the murders.
The night of the murders?
Yes.
What was he telling you about that he was at the house the night of the murders?
That he'd been there 30 to 40 minutes.
Was he telling you that? Did he ask you anything about that when he was talking to you?
Yes.
Did he indicate to you what he wanted you to do with that information?
No. No.
What did he say?
He just said that he was at the house. The 30 to 40 minutes, I said.
He said what? Was he there 30 or 40 minutes that night?
Not to my recall.
Why are you crying, Miss Smith?
Because they're a good family, and I love working there. And I'm sorry all this happened. They're good people, you know.
He wasn't there no 30 or 40 minutes, was he?
No.
Can't leave the witness.
Did that conversation upset you?
Somewhat.
You upset right now?
Yes.
Did you call anybody about it?
My brother.
You called your brother after that conversation with Alex?
Yes.
To tell him about that conversation?
Yes.
So Alex told her that he was at his mom's house for 30 or 40 minutes. He told her that, and she knew that he had not been. It had been a much shorter time. He was trying to establish an alibi, and having her as an alibi.
Just to be clear, what was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know
I was here 30 to 40 minutes.
Not to pry, but I can't help it sometimes. What else was going on in your life right there?
Just working, hours and hours.
You're whispering. I can't understand what you're saying.
Were you going to get married?
I was planning on getting married. I was planning on to.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes.
And when was that?
The day afterwards, I'm thinking.
The day after this?
I'm thinking it was,
after
yes.
the conversation
yes.
you just said? Where were you?
At the house.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, just let me know because the wedding's going to be expensive. I said, well, thank you.
The wedding's going to be expensive?
He said, wedding's going to be expensive. I said, well, thank you.
Did he offer to help?
Yes, he offered. That's the type of person, a good person.
And did he ever mention the wedding to you before?
No. Mm-mm.
Did you mention that to him before?
No.
Did he have a conversation, anything else about your job? Were you working at the school?
Yes, at the school, yes.
Did Mr. Murdaugh mention to you about your school and your position there?
Yes.
Tell him what he said, please.
He said that, if you need a position at school, my good friend is there. I said, yeah, I know, worked at the school, the principal.
So he basically offered to get her a raise or a new position, as well as pay for her wedding.
Did you help out more than just your regular shift the rest of this week?
Yes.
That week after
yes.
The murders and Solicitor Murdaugh's death, were you working full-time then, trying to help?
Yes.
Was school out then?
No.
So were you still going to school and helping?
Yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes.
Do you know how long it was, how many days after the funeral of Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning.
Say that again?
6:30 that morning.
And that had been a part of your regular shift, right? 8 to 8 a.m.?
Yes.
And did he call you and tell you he was coming?
No.
He didn't? Well, had he called you on June 7th and told you he was coming?
Yes.
And he was right outside the house?
Yes.
And this morning at 6:30, he did not call you?
No.
How did you know he was on the premises?
He knocked on by the bedroom, the window.
Knocked?
Yes, on the wall.
Well, did you hear him say anything after that?
He said, I'm outside.
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir.
Never?
No.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex Murdaugh.
He came in the white truck, came in the white truck.
Was there still funeral stuff's not in the world road? There's still funeral equipment in the yard?
Yes.
Like what?
The tent was still there, and the big old building that they put the food in had out there.
Like a food truck?
Yeah, food truck, yes.
And was that blocking your view some?
Yes, blocking my view, yes.
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
Yes.
Then what did he do?
Came inside.
And was Miss Libby sleeping?
Yes, she was still asleep.
Okay. Did he go check on Miss Libby?
No, he didn't come in.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
Okay. And did he have anything, or was he holding anything?
He had a blue something in his hand.
Say that one more time.
A blue something in his hand, something blue.
A blue something in his hand. And can you show me how he was holding it?
Like this.
Is it all right if I touch it?
Yeah, that's fine.
How was he doing it?
Like this, like that.
Holding something like this?
Yes.
And what did it look like?
Like a blue tart, like a tart.
Blue?
Blue.
Okay.
Tarp is what she's trying to say.
Was it vinyl?
It's like a tart that you put on a car, you keep your car covered up.
Big thing?
Yeah, blue. Yeah.
And was he holding it like this?
He was holding like this.
Could you tell if there was anything in it, or do you know?
No, I couldn't tell.
Okay. But not holding like this? Did he say anything when he walked in?
No.
Okay. What did he do when he walked in?
Went upstairs.
Make course notes.
There are pictures. Here come the pictures. Blue tarp is what she's trying to say. She's calling it a tart. I think she's just mispronouncing it. But she's described it as like the sort of thing you cover a car with to keep it from getting wet. You know, if you have a car that you're trying to protect from the elements. This is at 6:30 in the morning.
United States 230. $223, $222, $413, $412. At this time, without objection, I'll save the other two. I didn't call it.
They're admitted without objection.
You testified Mr. Murdoch came in your Alameda residence that morning. This is States 223. Do you recognize that?
Yes.
What is that?
Upstairs, going upstairs.
And is that where he went, Alex Murdaugh, that morning?
Yes.
Carrying some blue thing? And this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house?
Yes.
States 413. What is this?
That's the bedroom.
Okay. Where in Alameda is this bedroom? First floor, second floor?
First floor.
Okay. Is this where Miss Libby stayed?
No.
And 412. Is that the same?
Yes, same bedroom, yes.
This is at Alameda. This is where his mom is being cared for by this caregiver. I think we're getting to the raincoat. Yes.
We'll show you what's marked 411. Don't call out the answer. This is States 411 for identification at this point. Do you see the blue object in the center.
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue.
Is it vinyl?
Yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is State's 411 we'd offer at this point?
No objection. Is that admitted?
It's going to go on the Elmo here, I think. He's getting ready for the dun-dun.
Let me just, I don't know how to ask it except to ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay, where'd you see it?
in the bedroom, that
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize. Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes,
Did you you end up leaving at some point that day, right?
yes.
When you came back the next day, was that there?
No, it
It
wasn't.
was gone.
Yes, it was gone.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no,
Did you actually see him leave the house after he went upstairs?
yes.
And where did he go?
Oh, I don't know. He just left outside and left.
Okay. Did he say, hey, I'm leaving?
Yes, he said, I'm going, yes.
Okay. And at that point, what did you think? Did you think he'd gone?
I thought he left, yes.
Okay. Did you see him after that?
Yes.
Okay. Tell them where, please.
He came
That
back.
morning.
He came back to the house.
And how do you know that?
Because the blind was open, I seen him came through the driveway.
And what did you see him, was he walking, was he driving when you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, if I'm not, what truck was he driving?
the white truck.
And whose white truck was that?
I'm thinking it was Mr. Randall. I thought it was his truck. He had the white truck also.
He had a white truck also?
Mhm.
Okay. So when you saw, you testified Mr. Murdoch coming back in a white truck, that was Mr. Randolph's truck?
Objection, Your Honor, please.
Whose truck was it?
I don't know.
Ma'am, you must use words as opposed to, or because we need to know exactly what you're saying. Say yes or no if you can.
She said,
Whose truck did you think it was?
I thought it was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day of that, the same morning.
Same morning when Mr. Murdoch was there?
Yes.
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone? Do you know where he went?
No,
And when he came back in this white truck, what did he do?
he got in the other truck.
How long was he gone?
Probably about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there in the way, so I couldn't see it.
So that blocked your view?
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck.
Do you know whose that was?
No.
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
They had like a little color, a little bruise cut or something.
And ma'am, I apologize, a little what cut?
Like a little bruise or something.
Where was it?
It's like above his forehead.
Okay, I won't ask you to touch me, but can you touch yourself to show where?
Right here, something right there.
Did it look fresh?
This looked like a cut, not, I wouldn't say fresh, but it looked.
Was system in the house for either Solicitor Murdaugh or Miss Libby Murdaugh?
Yes.
Okay. Can you tell them about that? Where was that? What was that?
It was in the Miss Libby's bedroom.
And how was that activated or operated? It's better. Do you know?
No.
Okay. Was it on all the time or not?
Yes.
Okay. And what color would it be if it was on? Was there a marker or a red and black or red and green?
Mm-hmm, those circles, yes.
And would there be times when that wasn't on?
Yes.
And do you know who controlled it?
No.
Get the helmet.
Hey, Mary, it's a great day to be in court here. This is some incredible testimony that definitely makes Mr. Murdaugh look like he was trying to set up an alibi.
I'm going to show you what's marked 410. Do you recognize this?
Yes.
Okay. And does it relate to what we're talking about this morning as far as your location?
Yes.
Your Honor, 410, I believe without objection.
Says it relates.
They want more groundwork.
No objection.
It's admitted. Without objection, it's admitted.
Can you see this on your, you got a little thing up there?
Mm-hmm.
Creighton's the Elmo master there. Get everything centered and zoomed in just right.
Coming down here? Judge, can she come down here? Yes. Very briefly, it won't be long. If you would stand up there so just so we don't block the jurors, please, so Mr. Griffin can see. Is this a picture of what we refer to as Alameda?
Yes.
Okay. And can you show where I guess I've called the main house? And I'm sorry we don't have a pointer. That's the main house. Mm-hmm. And you have to say yes for the record, please, ma'am.
Yes.
And down here, I know it's hard to see. Can you tell what that is? Sorry.
Fort Knox there.
Point to the main house again. I think we blocked some jurors. That's all we're doing.
Right here.
Is that where you took care of Miss Libby?
Yes.
Okay. Now down here, there's even a little O on it. Do you know what this is down here? Let me ask you this: what other buildings are on the property?
The smokehouse and a barn, another little shed.
Not sure if she's ever seen the aerial photographs of the picture.
That's it right here.
There you go. That's the smokehouse.
Mm-hmm.
And that's where the ATV was.
Yes.
And where did the ATV end up when you saw it after you thought Mr. Murdoch left? Had it moved?
At the main house.
Say that again, please.
At the main house.
Okay. And when you saw him coming back, you thought he'd left. Where did you see him in the white truck? Do you remember?
He left him across the railroad track, you know. He left him across the railroad track and went out.
Which way to railroad tracks?
She's not used to seeing an aerial photograph of a property.
This way, I mean, that's the house. So had it been around, just had to drive through.
You're not going to say anything, but speaking up.
I'm trying to.
That's good. Go back and sit down. That's fine. Thank you.
Right. DMB. She's a caretaker, not a cartographer. She's familiar with what it looks like out the window, with where everything is located based on ground level observation, and then trying to pinpoint things on an aerial map Everything looks different, and so she's trying to figure it out. That's not her expertise. So what's this about the four-wheeler? He shows up, takes the four-wheeler around. He's gone for 15 minutes or so. Leaves it back at the house and then leaves. That's why we're thinking the something was stashed somewhere or hidden.
Now, have you talked with either Mr. Griffin or Mr. Harpootlian or one of their investigators?
Yes.
Okay, when was that?
Oh, I can't remember.
Best you remember. I'm not looking for a date and time, but you know how long?
Yeah, we are.
It was last year.
And I met with you a couple of weeks ago?
Yes.
And just a little while ago this morning?
Yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
Okay. And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes.
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in?
Mm-hmm.
Is that him?
Yes.
Thank you, that's all.
Thank you, Your Honor. Good afternoon, Ms. Smith.
Good afternoon.
We have met once or twice. Did anyone ever show you a blue rain jacket?
No. No, that. Yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket.
Yeah,
correct?
picture of it, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No.
Now, you saw Mr. Alex Murdaugh bring a tarp in, you said, right?
Yes.
And I'm going to show you a tarp, which we marked for identification purposes, Your Honor, Exhibit 86. Is this the type of tarp that Mr. Murdoch came in to the Alameda house on the day that we're talking about?
Yes.
Yes, Mark.
Tarp like this that would maybe cover up a car. Is that right?
Yes.
Any way to confuse this with a rain jacket?
No.
He was not carrying a rain jacket, was he?
No, it was balled up. I don't know him.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up. Is that right?
Correct.
Have I balled it up sort of correctly?
Yes.
All right.
No, we have no objection to that going in.
Your Honor, move Exhibit 86, I think, into evidence.
It's a fresh tarp.
Without objection.
From Lowe's or Home Depot.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
Yes.
Okay. And you had, and when you left for end of your shift that day, that's where it was, right?
Mm-hmm. Yes.
And you've never seen it since, correct?
Correct.
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
No. In the closet.
Do we have that picture? What's the last photograph that went to evidence? Can you see that, Ms. Smith?
Yes.
Do you know where that is in, or even if it is in Ms. Libby's house?
I couldn't say because I don't be in the closets. I don't know.
So you don't even recognize the closet, is that right?
Correct.
And have you ever even been upstairs in Ms. Libby's house?
Twice.
2 times over how many years?
3 years.
2 times in 3 years. And do you know where Alex Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
No.
Okay. Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral. Is that right?
Yes.
Okay. And it was early in the morning?
Yes.
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
Yes.
So then it would be Monday, Tuesday, Wednesday of that week. Is that right?
Yes.
Okay.
That's correct.
And is that the morning that you said that you thought you saw a bruise on his forehead?
Yes.
So it was Wednesday after Mr. Randolph's funeral.
I'm thinking I can't remember. It's so long I can't remember.
Yes, ma'am. And the and you mentioned that that he came in a truck. I think you said he drove up in a white truck.
Mm-hmm.
Is that correct?
Yes.
And he does have a white truck, as
Yes.
far as you know, right?
Yes.
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alex's truck that he left in?
Because it was moved. Mr. Randolph had always keep his truck in a certain position, certain part.
So you think he left in Mr. Randolph's truck and moved?
Yes.
Okay. And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway?
Yes.
Parked in its normal place?
Yes.
Anything out of sort?
No.
Was it all covered up with mud, like someone's been mudding in it?
No.
Anything unusual about the truck?
No.
Okay. Now, you mentioned there was a four-wheeler that had been moved at some point in time. That four-wheeler had a flat tire, didn't it?
Yes, it did.
Okay, was it a front tire, back tire?
I think it was a back tire.
And it was moved up close to the house?
Yes.
As far as you know, so the tire could be repaired?
Yes, it was moved from the smokehouse to the wreck house, yes.
With a flat tire?
Yes, with a flat tire.
Now, you were asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes.
And he said he was there 30 to 40 minutes.
Yes.
And you said, no, I don't think it was that long.
Yes.
And then the next day, I think you said, or day after, well, the following day, or I guess that would have been a Monday, you had another conversation with him where you just brought up back that you were going to get married. I think you said that was a different day, right?
Yes.
And he was just being nice, wasn't he?
Yes.
And I think you used the word good person.
A good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Okay. Now, he came over on the night of June the 7th, and you said it was somewhere between 8:30 and 9:30 in the evening?
Yes.
And that's just your best estimate of when he got there, is that right?
Yes.
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
Yes.
Now, when you said 15 to 20 minutes, are you talking about 15 to 20 minutes in the room with Ms. Libby, or on the property the whole time?
On the property the whole time, thank you.
Okay, well, now, you said it took you about 5 minutes to let him in, is that right?
Yes.
So, are you including the 5 minutes it took him to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes, only thing is
No.
the whole time, so.
And you would agree that Alex Murdaugh would visit his parents frequently, right?
Yes.
And he would always come over more so than any other sibling, is that right?
Yes.
And you would agree that it was not out of the ordinary for Alex to come at night, correct?
Yes.
You would agree with that, right?
No.
So you don't agree that is, so was it out of the ordinary for him to come at night?
Yes, on my shift, yes.
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? Do you remember that?
Yes.
And do you remember telling him that it was not out of the ordinary for Alex to come at night?
Yes, it's been long and I couldn't remember. It's been a year now, so I can't really remember.
I mean, is it possible that you told him that?
Yes.
And here today, you said, as I have in my notes, that when he came over that he was acting kind of fidgety, yet normal. I believe that's what you said.
Mm-hmm.
Is his normal behavior kind of fidgety?
Yes.
He's just kind of a fidgety person, right?
Yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
Well, he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes.
Okay. Now, you mentioned the clothes that he was wearing, and he came in and he sat on his mom's bed.
Yes.
Lay down next to her.
Laid. Mm-hmm.
And held her hand. Is that right?
He walked in and held her hand and spoke to her, then went on the bed and lay down.
And lay down.
Mm-hmm. Not lay down, but sit up.
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall that I didn't touch it.
Okay. Did Alec Murdoch have blood on his clothes?
No.
He had blood on his shoes?
No.
He had blood on his hair?
No.
Did he leave blood in his mom's bedroom?
No.
Now, according to the records that we've been provided in this case, you were interviewed by SLED on June 16th. Do you remember that interview?
Yes.
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes.
Okay. And then you were interviewed again by telephone on June 17th. Do you remember that follow-up call? Do you remember having a short phone call on the 17th?
A phone call.
Okay. Well,
SLED is South
whether
Carolina
it's
Law
one interview
Enforcement
or two
Division.
interviews, you never told anybody at SLED in June, in these interviews, one or two, anything about Alec coming in with a blue tarp, is that right?
Right.
You didn't say anything about a blue tarp until sometime in September, is that right?
Yes.
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale Police Department when he was working a wreck. Do you remember that?
Mm-hmm.
Is that yes?
Yes.
Okay. And you had been in the automobile accident, and Officer Dingle was working the wreck and I guess filling out an incident report, and you were having a conversation with him.
Yes.
And in that conversation with Officer Dingle, didn't you tell Officer Dingle that on the night of the murders that Alec came over with a blue tarp that looked like it had a gun in it?
No, I saw him like he was holding something.
So you didn't say?
I didn't say specific was a gun. I said he was holding something.
So you didn't tell Officer Dingle that he came over, and you couldn't tell, but stated it looked like a rifle?
No, I said it was like he was holding something. I did not say it was a rifle.
Okay. And if Officer Dingle wrote a report up saying that, he was just incorrect?
Yes.
Okay. And then after you had this conversation with Officer Dingle, then you were contacted by SLED agents, right?
Mm-hmm.
And they asked you to go down to their offices, and that's where you were interviewed in September, right?
Yes.
And in that interview, you told them about a blue tarp that you put over your car just like this, right? Is that correct?
Yes.
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle?
Right.
Okay. And since that day of the interview at the Low Country SLED office, have you had any additional interviews with SLED agents other than getting ready for trial this week, last week?
Yes.
How many additional interviews?
2 or 3.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alex Murdaugh walking into the house with?
Yes.
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
And it was balled up as a blue tarp.
Because you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes, yes.
One second, Your Honor.
Alex directly participated in the
just one more
questioning
point.
discussion.
When Alex Murdaugh came over on that early morning, I guess it was Wednesday, you testified. Were you in Ms. Libby's room?
Yes.
And you can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you?
Mm-hmm.
You can?
No.
Okay. Thank you, Your Honor. That's all the questions I have.
Redirect.
testifying in front of the grand jury on January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total. Do you remember that?
Yes.
Do you remember your answer being 20, 10, 15, 20 minutes?
Yes.
Mr. Griffin asked you about the 30 to 40 minutes.
Mr. Griffin is like,
Why'd you call your
chomping
brother
at the
after that?
bit.
Because he's a assistant chief police at Warrenville, so I called him.
Had that statement by Alex Murdaugh affected you?
Yes.
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No.
And his 9:30 visit the night of the murders, that was very unusual for him to be at night, wasn't it?
Objection, leading.
Don't lead the witness.
I'm sorry.
Yes.
Was that unusual?
Yes.
So there was an objection, and he got the answer anyway, even if after the judge said don't lead.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying?
Yes.
Before you told anybody else?
Yes.
And what was that about, a traffic accident?
I had someone hit my car, and he was on duty.
And when was that?
September 11th.
That's my birthday.
Okay.
You had an accident, and you told the officer that you had seen him, Alex Murdaugh, come in holding something?
We was talking, just having a conversation, and that came up.
And you just told him that?
We was talking.
Had anybody asked you that before?
Mhm.
You have to say yes or no.
Yes.
Had
No.
anybody asked
No.
you that before?
No.
Okay. So why did you tell the officer that on September 11th?
We was having a conversation, and just talking in general, and he asked me a question, and I said, yes, I've been there. And I said, I work with the Murdaughs, to keep, his mother.
In response to him, you told him you saw Alex Murdaugh with what?
A lining, a blue tart.
And you saying tart or tart?
Tart. Like you cover a car with a tart.
And you said you saw him with that, and did it appear he was carrying something?
Like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes.
Like this?
Yes.
So you never saw this unfolded?
No, I never saw it.
Never?
Till the next morning, so it was on the chair in Miss Vickers' room.
And you don't know where this tart came from, do you?
No, I don't know where it come from.
And it didn't have silver on one side, did it?
No.
It was all blue?
All blue.
And you said that the defense took a statement from you?
Yes.
Did they record it?
Yes.
Your Honor, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking the stand.
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, I think once the witness has taken the stand and she said that they took the statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
Rule says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
The counsel's like, I'll wait.
Your Honor, we do have a copy here. I don't know if we can download it to, you got it?
Yeah. Is it okay to produce it on a flash drive? Judge, I mean, I can't look at a flash drive, but yeah, I guess. Is it a hard copy?
This is funny. Well, I think he was looking at the phone book. Honestly, I think he was picking up the phone book to call somebody.
Opportunity to listen to that without the presence here. I would assume it would be a hard copy, but I don't want to mess the court schedule up either.
Now, ladies and gentlemen, we'll have you go to the jury room. Please not discuss the case.
Oh my goodness. This is good. This is good stuff. Another exciting moment. He's looking at prosecution for dummies. His ISBN number. Oh man. This is good stuff. These are a couple fun moments this morning, and the jury got to see that one. It'll be interesting. I think what you're going to have in that recording is probably her agreeing to the timeline, in the 15 to 20 minute timeline. Wish we had mics back. Here we go. This is made up for a lot of slow days in court. This is a good day.
At ease momentarily.
At ease momentarily. They're going to show us the wall or the light, one of the two, maybe all three. Let's just watch here, just so we get any hot mic moments. So they're going to have to produce it. She is saying tart instead of tarp. I believe that's just it's how she pronounced it. I think she thinks that's what it's called. The actual name is TARP, T-A-R-P, but she's described its use, and I think we're clear that she means tarp. What's a phone book? Defense got caught with their pants down just a little bit. It'll be interesting. Can we just have lunch? It would be nice. I think we're going to get lunch right after this. They produce this information. They're gonna do a quick scan of it. They'll probably play that part where she says how long they were there, or possibly have something to do with the actual tarp or the raincoat. I don't know. The prosecution, I think, is hoping it's good. If they don't have a copy of it, that's they don't know exactly what's in it. Monday out to the races for sure. Did the defense just step in it? No, they. She's saying tarp. Yeah, nobody says the full name, Gordon. I think that word is actually non-existent anymore. We just say tarp. Could the raincoat being wrapped in the tarp? I think it was a raincoat. I think that's what we're going to find out. A blue tart does sound very good, though. Very tasty. Yeah, don't you think this would have been the perfect time for a lunch? Yes, it would have been, but you've got to realize the jury just got there. The judge is probably going to use them for a little bit. Tarp sales just increased. Hopefully you bought stock in blue tarps. The fact the defense did not produce a copy for the prosecution, in my opinion, is very telling, says Kathy.
Please be seated.
Now they ask nicely. Sometimes they yell at them to sit down.
Well, let's see. If you need a half an hour to listen to
that sounds like lunchtime.
We can take.
Your Honor, we have a rough draft of a transcript that we're emailing to them, but it's 57 pages long, but we're sending it to them.
Guess who's working through lunch? The prosecution is. They're probably going to divide it up and play it.
A rough draft.
I'd like to look at the video at this point.
All right, we're going to bring the jury in and break for lunch.
Okay, so we get lunch. It sounds like something's good. Something good's coming. He said 57 pages, DMB. 57 pages. Light reading on the lunchtime. Somebody's not going to get to eat, and I think it's Creighton. Creighton's going to skip his lunch today, which means he'll probably want to end early and get a good dinner, because we're going to hear what defense asked her and what she said there. There might be something in there that's juicy, that's spicy, that brings the objections. Lunch is going to happen for sure. We want the audio, not the transcript. He said they wants to play it. Creighton said he wants to play it, or at least the prosecution, that wasn't Creighton, says he wants to play it. The Snickers bars all around for prosecutors. Samantha, go walk the dogs after lunch. It's going to be great. You don't want to miss it. We're gonna stop the stream here once they break. Just give them a minute. The jury's just about in the courtroom right now, I think. 2 minutes per page with transcript, says DMB. Creighton's going to hit the bar early tonight. I haven't seen Harpootlian do just about anything today. He's just been kicking back, taking it easy. I think we've got the soundbite for that as well. Where's that at? Not subject, but there we go.
I was kicked back, taking it easy.
That's Harpootlian today. Yeah, Kelly, I think you're right. It's just a dialect. Arkansas is going to eat some pickles. Please do. I have some as well. I wonder what a tarp would taste like. It would taste blue. What are we waiting for? What docs? I told you work is my way today. Tish, what we're waiting for is this woman, the caretaker that took care of his mom. Let's wait just 1 second here.
All right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30.
2:30.
2:30. And
own it, Judge. 2:30.
This is juror number.
What's the juror number? He wants to talk to somebody specifically.
Juror number 729, I'll speak with you during lunch. So you can return to the jury room, please.
Juror 729. So I'm not gonna brag here, but my young one just brought me something here. We're gonna go back. So I've got a salad. We've got avocado, bacon, tomatoes. Looks like shredded mozzarella, lettuce, everything. Looking good. I wonder if the judge is going to talk to the juror on camera, like mic's on. What did you do? 729 may be in trouble or may have a question. We know that earlier in the trial, the jury actually was asked the
We're going
judge.
to take a break for lunch. You just cannot discuss your testimony with anyone during lunch, but you can step down and have a good lunch.
Okay, so the witness gets excused.
And we will be in 2:30.
Looks like we're not going to hear 729. I'll keep the mic going just in case. But let's see. So earlier, the juror, they were upset. They said, remind the reporters in the audience that we're supposed to be anonymous. Apparently, if you talk to James from the court, he says, I think they were talking about me because he'd been intently following and staring and watching the reactions of the jurors, so much so that they got nervous, and he's the one that they sent the message to the judge about. Let's see. So 2:30 is the time, which means we're going to come back about 15 minutes before that. We'll be back 2:15 Eastern time. Right now I show 1:15. That gives us a 1 hour break. But let's answer a few questions here because I know some people have been popping in, popping out. Get a little update. The salad looks amazing. I'm just letting it waft up through the microphone. If you can smell it, it's close to the microphone now. So you can take a deep breath and you can smell this delicious salad. Yes, bon appetit for sure. If you show your lunch, you have to share it, says Debbie. If you can get here before I finish, you're welcome to part of it. Harpootlian shot himself in the foot and might be worried about doing it again. He has had some less than stellar presentations, and especially where he went up against the judge and the judge sort of put him in his place. Dibs on the tomato. I've got lots of mini tomatoes on here. I don't think it was a problem. James from the court, he's allowed to watch anybody he wants to in the courtroom. And it's not like he's taking photographs. He's just watching for their reactions and trying to get a read on them. And they were just a little nervous. Oh, the car just raced past my house. They were just a little nervous. Food trucks are going to be hopping after today's morning activity. Yes, for sure. Hopefully they're doing great business down there. Good for the economy and everything. Does anyone need a catch-up? Not like ketchup for their lunch, but... I think we're on pace. We've got the ruling. The big thing from this morning is the judge ruled that the 404B evidence is coming in. All that financial stuff that we heard, we're going to get it in a little bit more depth than we heard it initially. So that was the big thing that happened this morning. So I don't even know where to start there. It was a crazy morning. There's a ton of information that comes in. What does the X on the tree mean? I think those are... I think they're like cannons. I think it's like X marks the spot. Here's the treasure. I don't know. I'm not sure. They were talking about the seal, the South Carolina State seal. I'm super excited about the evidence, the financial evidence that comes in. This is he's opened the door for a lot more. There's going to be a lot more information that comes in as we talk about Parker's, about the store that sold the alcohol, as we talk about just all of that in front of the jury, and everything that we heard that we thought the jury needs to hear this, they're going to hear. Yes, it's an appeal issue, 100%. The defense has already said we're going to object. You made your ruling, Your Honor, but we're going to object right at the beginning, not to be insulting to you, but we're preserving our right to appeal. They will appeal if he gets convicted on this. Whether or not that will be granted or not, that's another topic. But they are going to object, and the jury's going to hear all of this, and it will be spicy. It will be emotional. It's going to be crazy. What happened regarding the private meeting weekend cliffhanger? That one, the judge basically said there's no. I didn't like the judge's ruling. It's almost like he wasn't understanding the question, because what happened is you've got this meeting where a lot of people were there. Most of them were attorneys. A couple of them were not. Even though they were, most of them were attorneys. Some of the people who were attorneys were not acting as Alex's attorney, and thus were not part of an attorney-client privilege. And so a conversation went on. And one of them overheard this conversation and has information about what they were talking about. And the judge basically said there's no expectation of privacy there because of that attorney-client privilege. It's not protected. And so, yes, you can pursue questioning what he knows. So that we don't know. That Creighton doesn't know yet. He said, I've made really sure that I don't find out what it is in case it is protected. I've waited for your ruling, Your Honor. Now that you've ruled on it, now I'm going to find out. So during his lunchtime, he's watching a half-hour-long, video of this witness, this last witness, the caretaker, done an interrogation done by the defense that they did not provide to him. But the judge ordered they need to, so he's provided that. They have 57 pages to read through as well, the transcript, rough transcript. So he's doing that, and he also has to find out exactly what this witness did, this former law partner of Alex Murdaugh, what he heard in this conversation. So he's got all this to go through. I'm not sure if we'll get all of it today, but it sounds like right after court we're going to start with this witness and this video and hear what she told them. So that's going to be fun. The tarp rain jacket thing, we'll hear more about that. I think it was a rain jacket, and she thought it was a tarp. That's what I think. But it sounds like everything the judge has ruled on today has gone in favor of the prosecution. And Alex does not look like he's enjoying it at all. Still want to know what's happening with this juror. We might have a juror dismissed for some reason. We have some spares. We keep spare jurors around for that very reason. But juror 729 has been asked to stick around just for a minute, talk to the judge, just to make sure everything's A-okay. And we'll see. If a juror is dismissed, both sides will be informed about what happened and everything. And I would expect that if a juror is dismissed, that the defense will ask for a mistrial right then. But that just seems normal. Sarah King says, I need caught up on the tarp, rain jacket thing with a witness. Sarah, basically the caretaker saw Alex bring a blue vinyl wrapped up bundle into the house. The house she's talking about is his mom's house at Alameda. And he brought it in and, left it. And he saw it spread out on her chair or something. And then it was gone the next day type thing. That's it. At the same time, there was, several different trucks that were used or moved around the property. He arrived in one, drove another one, then left in another sort of thing. The four-wheeler was moved from the smokehouse up to the property. It had a flat tire. Just some strange things happening. And mostly his being there, both late at night and early in the morning, was odd. It was not normal. The biggest gotcha moment that we heard from her during her testimony is when she said he showed up the night of the murders. Okay, he didn't say anything about the murders, but he was there for about 15 to 20 minutes total, including the 5 minutes he stood outside the house waiting for her to let her in. Michelle, the judge, did rule on 404B, and he's letting it all in, everything. So Alex Murdaugh's out there for 5 minutes, then she lets him in. He stays on the property the entire time he's there for about 15 to 20 minutes and then leaves. The next day, I think, he's over at the house and says to her, basically, I was here for 30 to 40 minutes yesterday. And she gets this gut feel. She's like, oh, crap. And who she calls? She calls her brother, who happens to be a police officer, a chief of police or assistant chief of police at that time. And also at the same time, Alex Murdaugh's like, oh, by the way, you're getting married. That's going to be expensive. You know, like to help with that. Do you need to upgrade on your job over at school? I know the principal type thing. It's all in one conversation. And by the way, I was here 30 to 40 minutes. That's burning. That's smoking. Can you convict on no fire but enough smoke? There's a lot of smoke there. Yes, you can, Ed. You can convict with just on circumstantial evidence. Did the tarp have GSR? I think it's a raincoat, and yes, Cans fan, I think that's where we're going to get on that. Okay, this salad smells delicious, and you guys are trying to stall me until you can come steal my salad. I know what you're doing. I've seen this ploy before, and it's not going to work on me this time. We are going to take a lunch break. If you want more of this, come back and watch after lunch. We're going to have about an hour, a little less than an hour, maybe a 45-minute lunch break, and we'll go live again. Come join us. This is the best place on the internet to watch true crime. It really is. When you come back, bring a friend. Make sure they behave because you're responsible for anything they do. They break it, you buy it. That's the deal. But please hit the subscribe button. Like if you can. Both of those are free. I do appreciate it. You guys are amazing. We'll play a little bit of music to get ready for lunch. Thank you, all mods. If you're not coming back, if you've got something that's real life calling, I understand. It's not required that you be here, but I will mark you absent, and it will count against your grade at the end of the term. So anyway, if you're not coming back, please tonight when you go home, hug the people you love, smile at somebody, make their day just a little bit better, and please stay safe till you do join us again. We're going to go live here in about 45 minutes. We do this every morning at 9 a.m. as well. So thank you guys. We'll see you in a little bit. Enjoy your lunch. All right.